2018 and takes place at the Commission's headquarters at 1331 Pennsylvania Avenue Northwest, Suite 1150, Washington, D.C. 20425. I'm Chair Catherine Lehman, and the commissioners present at this briefing, in addition to me, are Commissioner Adegbile, Commissioner Harriet, Commissioner Chladni, and Commissioner Asaki. On the phone, if you could confirm that you were present when I say your name. I believe we have Vice Chair Timmons Goodson.
Present.
Thank you. And Commissioner Yaki? Not yet present. A quorum of the commissioners is present. Will the court reporter confirm for the record that you are present? Thank you. She's nodding and waving. Mr. Staff Director, will you confirm for the record that you are present?
I am present.
Thank you. Welcome everyone to our briefing titled Federal Me Too, Sexual Harassment in Government Workplaces. In today's briefing, the Commission looks to our own sector, that of federal workplaces, to assess how well the federal government is addressing workplace sexual harassment. We examine the Equal Employment Opportunity Commission, otherwise known as EEOC's, enforcement efforts to combat workplace sexual harassment across the federal government. Factors that we expect to review include the frequency with which federal employees make sexual harassment claims and the frequency of findings of harassment, the resources dedicated to preventing and redressing harassment, and the impact and efficacy of those enforcement efforts. In addition to cross-agency federal perspective that examining the EEOC offers, the Commission has also selected 2 federal agencies for focused evaluation of agency level practices. Those are the State Department and the National Aeronautics and Space Administration, commonly referred to as NASA. I will say as a personal aside that we had a scientific basis for choosing these 2 agencies, and it's not just because they're cool, but I will say that my teenage daughters and their friends often wear clothes with NASA emblazoned on them, and it does remind me of how important it is that this workplace, among all workplaces, is egalitarian in its practices. So I look forward to this examination. We will hear from current and former federal government officials, including from the EEOC, NASA, and the State Department, academic and legal experts, advocates, and individuals who have experienced harassment. Today's briefing features over a dozen distinguished speakers who will provide us with an array of viewpoints as well as the opportunity to hear from the public. Panel 1 will include a member of Congress, as well as current and former officials from the EEOC, as well as outside experts. Panel 2 will include current and former officials from NASA, the State Department, and STEM organizations. Panel 3 will include academics and community stakeholders, and Panel 4 will include legal and community experts. The day will conclude with an open public comment session during which the Commission will hear from members of the public who wish to present additional information to the Commission. I thank all who join us. To focus on this critical topic, your views help us to fulfill our mission to be the nation's eyes and ears on civil rights. I now turn to Commissioner Adegbile, at whose instigation we are engaged in this investigation.
Good morning. Thanks for joining us. I think we're going to have an important discussion today and learn some things about an issue of tremendous importance to the country and many of our American people. Like many forms of discrimination, sexual harassment shares some common characteristics. It imposes painful, sometimes lifelong burdens on victims. It thrives where people are willing to abuse their power. It is disproportionately borne by a particular class of people. It demeans human dignity. And there are costs for those who assert claims and costs for those people who choose not to assert claims. Leaving it unaddressed is corrosive personally and has societal effects. The Me Too movement also shares some common characteristics with movements. It gives voice to people who felt voiceless. It lets people know that they are not standing and suffering alone. But it's not just about highlighting an injustice. It's a call for a response. And so today, the U.S. Civil Rights Commission turns its attention to this very important issue to learn and ask the questions about whether or not the federal government is using all of the tools it has, and frankly, to inquire and learn about whether there are more tools that we need to use to address this issue that is an issue of human dignity, of justice, and poses a special kind of threat when it is tolerated on behalf of the United States government. Thank you, and we welcome all of your testimony.
Thank you, Commissioner Degblay, and I add my deep thanks to our commission staff who have brought us to today for this briefing, and also I thank Staff Director Morales for his leadership. I caution all speakers today, including our commissioners, to refrain from speaking over each other for ease of transcription and to allow for sign language translation to my right. For any individuals who might need to view the sign language translation, there are seats available in Clearview. I ask everyone present to please silence your phones and not to take flash photos to minimize health risk to persons present. And in addition, Patty Pazinski and Megan Williams are both licensed clinical social workers with the Executive Office for United States Employee Assistance Program. And the Employee Assistance Program provides confidential mental health support, training, management, consultation, and crisis response for more than 10,000 federal employees working at EOUSA headquarters and the 94 United States Attorney's offices. Because of their clinical expertise and extensive experience in the field of trauma, we've asked them to be here with us today to support us through important but often difficult conversations. These professionals will be available if you need assistance. Please let a staff member know that you would like to speak with them, and our staff will direct you to the appropriate place. They also will be located at the back of the briefing room and are wearing name tags if you would like to approach them directly for assistance. As I mentioned, after the 4 panels and an afternoon break, we will reconvene at 5 p.m. for a public comment period. If you're interested in participating in the public comment period, during which each person will have up to 5 minutes to speak, we will be honored to hear from you. In total, spots at the public comment period are allotted on a first-come, first-served basis. If you did not already sign up for a spot online, you may sign up at the registration desk now. The spots will be available until filled. If you are one of the individuals who signed up online, please check in at the front desk so we hold your spot. For any member of the public who would like to submit materials for our review, our public record will remain open until Monday, June 10, 2019. Materials, including if individuals wish to submit anonymously, can be submitted by mail to the U.S. Commission on Civil Rights, Office of Civil Rights Evaluation, 1331 Pennsylvania Avenue Northwest, Suite 1150, Washington, D.C. 20425, or by email to sexualharassment@usccr.gov. During the briefing, each panelist will have 7 minutes to speak. After each panel presentation, commissioners will have the opportunity to ask questions within the allotted period of time, and I will recognize commissioners who wish to speak. I do strictly enforce the time allotments given to each panelist to present, so I encourage you to stay within your time so I don't cut you off. And unless we did not receive your testimony until today, you should assume that we have read your statement and you do not need to use that as your opening remarks. Please do focus your remarks on the topic of federal employment sector sexual harassment. I ask my fellow commissioners to be cognizant of the interest of each commissioner to ask questions, and so please be brief in asking your questions so we can move quickly and efficiently through today's schedule, and I will step in to move things along if necessary. Panelists, please notice the system of warning lights that we have set up. When the light turns from green to yellow, that means 2 minutes remain. When the light turns red, you should stop talking. And my fellow commissioners and I will do our part and keep our questions and comments concise. As we're just about to begin, I should also just confirm for the record, I believe Commissioner Yaki has joined us on the line. Commissioner Yaki, are you on the phone?
I've been on since your introduction.
Thank you. I'm sorry we missed you at the first round. So now we'll turn to our first panel, EEOC and outside experts. The order in which they will speak is Congresswoman Jackie Speier, who needs no introduction, but is from the great state of California. Welcome. And on the receiving end of whose powerful advocacy on this topic I have been, so I look forward to hearing your testimony today. Dexter Brooks, Associate Director of Federal Sector Programs at the Equal Employment Opportunity Commission. Sunu Chandi, Legal Director of National Women's Law Center, and George Chusey, Attorney at Kalijarvi, Chusey, Newman, and Fitch. Congresswoman Speier, please begin.
Thank you, Madam Chair, and to all the members of the Commission. Thank you for hosting this very important briefing today. Let me also say at the outset that I had the good fortune of working with your chair when she was the head of the Office of Civil Rights in the Department of Education and the Protectorate of Title IX. So we truly miss you, but California is very lucky to have you in your newest post. So in October 2017, actress and activist Alyssa Milano tweeted those immortal words, "Me Too." She said, "If all the women who have been sexually harassed or assaulted wrote Me Too as a status, we might give people a sense of the magnitude of this problem," unquote. Since then, it's been shared millions of times and became an indelible part of our national consciousness. The phrase, originally founded in 2006 by Tarana Burke, was meant to bring together all of us, to show we are not alone in our experiences. Like many of you, I have had my Me Too moment as well. As a congressional staffer, my chief of staff grabbed me one night, held my face, and stuck his tongue down my throat. I was astonished and shocked, and like many who have endured this, thought, what did I do wrong? As if we are the ones that had elicited this particular action. And then followed by a rush of humiliation and anger. So I decided to share my story after the Me Too movement got underway, mostly because I wanted congressional staffers to know that they had someone who had a similar experience and would have their backs. So I then was astonished to hear from so many women on Capitol Hill. I have indelled in my memory the vision of one woman who sat on my blue leather couch sobbing because a member of Congress that she had worked for a number of years had started to sexually harass her in ways that really undermined her. Another staffer told me about how she was propositioned in her office at her desk by a staffer who came by and unzipped his pants. One of these women said to me, "I have to keep this job. I am a single parent." And so their fear associated with the incident prevented many of them from coming forward and talking about it. It didn't stop there. 1,500 former staffers of Capitol Hill wrote a letter to members of Congress saying this has to stop. And so all of that helped in the work that we undertook to deal with this issue. But my work on this issue in Congress actually started back in 2014 when I attempted to get sexual harassment training mandatory for all members and staff. At the time, the Rules Committee chairman looked at me and said, "Jackie, we're never going to do this." Well, he was right for a period of years, but now we do have mandatory sexual harassment training for all staff, for all members, for all interns, and all fellows. So for far too long, Congress has been a breeding ground for harassment, and we finally have addressed it, I believe, in a meaningful way. Last year, we passed into law the Congressional Accountability Act, Reform Act, and it was bipartisan in nature and bicameral in its approach. I was joined by a very conservative Republican from Alabama. We don't agree on many things, but we certainly agreed on this issue. And because of that merger of thoughts and ideals, Bradley Byrne and I were able to move that legislation through successfully in the House and the Senate. So what is it we have now in the Me Too Congress bill? Survivors no longer are subjected to mandatory counseling, mediation, and cooling off periods. Workers can't be silenced by mandatory non-disclosure agreements. Interns and fellows have the same protection as permanent staff. And probably the most important element from the taxpayer's point of view, no longer will settlements be paid by the taxpayers of this country. Members of Congress will be required to pay for that settlement. The settlement will be initially paid by the U.S. Treasury, and then the member has 90 days in which to provide the requisite amount of money. And if they're unable to do so, they will have their wages garnished. And if that's not sufficient, their thrift savings plan garnished. And if that's not sufficient, their Social Security garnished. So we mean business. And I think that that one provision may have the most persuasive effect on people's behavior. At least I certainly hope so. But there's more work to be done. We are also going to be introducing legislation again this year that will make all members liable for any discrimination they perpetuate, because the original bill did not have that provision. So as we think about sexual harassment, it's really about power, that it can derail a survivor's career and well-being, both physical and mental, and that oftentimes the perpetrators are free to carry on. In November 2017, 223 women in the national security field came forward, again with Me Too stories. And I will be carrying legislation this year that is going to protect those in the State Department. But as I work on that particular area, I might point out to you that we have similar problems in so many departments and agencies across the federal system, including the Department of Interior, particularly in the fire service, and in many professions where there's a remoteness to people being associated with their peers and superiors. So I know my time has run out, so with that, I think I will conclude my remarks.
Thank you, Congresswoman. Mr. Brooks?
So good morning, Chairman Lehman, Commissioners. Thanks for the opportunity to be here today. My name is Dexter Brooks. I'm the Associate Director of EEOC's Office of Federal Operations. As you know, EEOC is the enforcement agency that deals with anti-discrimination laws as it deals with employment. But since we're here to talk about federal sector, I'm going to skip all the private sector stuff because the chair gave me explicit directions. So in the federal sector, EEOC serves two important roles in dealing with non-discrimination. We serve an adjudicatory function where there's an administrative process where federal employees who believe they've been the victim of discrimination can initiate a complaint with their agency. It's investigated through a regulatory process that we manage at EEOC, and investigates and finally issues a decision by the agency. If the employee is unhappy with that determination, they have the ability to take that action to EEOC for a hearing or appeal. My office serves as the final appeal of federal sector discrimination complaints. So that's one of our primary functions. Our second function is to provide oversight of the federal government as an employer. The federal government legislates that we should not discriminate based on the protected basis under our statutes, but the statutes also have the vision that the federal government would be the model employer. So we have a unique role in looking at federal agencies' EEO programs to ensure that they're operating efficiently and is managing their workforces in a way that maximizes opportunity. In this capacity, we're able to view federal agencies' trend developments and complaints, identify best practices for cultivating model work environments, and provide guidance to federal agencies to address their challenges. When we look at sexual harassment from those two lenses, whether it be adjudication or oversight, I'll start with adjudication. Cases come to EEOC after they've been initially processed by the federal agency. So roughly out of a workforce of 3 million employees that we have oversight for, we get roughly about 15 to 16,000 formal complaints of discrimination. When we look at those complaints of discrimination, the growing trend is now that over 50% of our complaints of discrimination contain an allegation of harassment. Now, the term, in terms of sexual harassment as a subcategory, is a much smaller number. 4% of our cases actually involve an allegation of sexual harassment. But when we get to the point of making findings, our most egregious findings of discrimination generally are on those issues of sexual harassment, even though it's a small number in our inventory. By comparison, in the private sector, 35% of our inventory is harassment and 10% is sexual harassment. When we look at the cases that we have made findings of discrimination in the federal sector, we see 4 trends that emerge. One that the Congresswoman just mentioned: isolated work environments are vulnerable to bad behavior. 2, 1, gender-dominated workplaces have increased vulnerability. 3, ineffective anti-harassment programs increase risk of repeated harassment and organizational liability. And 4, organizations fail to take the adequate personnel actions to address the conduct that's underlying the harassing behavior. On our preventative side, where we have oversight authority, EEOC has had a longstanding priority to address harassment at all workplaces. Beginning in 2013, we had a strategic enforcement plan with 6 national priorities. The 6th priority was to prevent harassment through systemic enforcement and targeted outreach. In furtherance of that, in 2015, EEOC established a select task force on the study of harassment in the workplace. It was headed by 2 commissioners, Hy Feldblum, who's a former commissioner, former Commissioner Victoria Lipnick, who's now our acting chair, were the co-chairs of the task force. The task force consisted of a select group of outside experts that actually met for over a year to come up with strategies to address harassment at all workplaces. The group submitted a report, and it was published on June of 2016. The report includes detailed recommendations for harassment prevention, including effective policies to reduce and eliminate harassment and recommendations for targeted outreach and future resources. Specific to the federal sector, in terms of our oversight authority, it derives from a policy document that we have. It's called EEOC's Management Directive 715. It sets forth what's required of federal executive branch agencies to establish model EEO programs. This directive mandates that agencies must have effective anti-harassment programs, which consist of a policy that prohibits workplace harassment on all protected bases, procedures for addressing such matters when they arise. This anti-harassment program, we should note, is different than the complaint process. It has to be something that's done immediately, not something that goes through the litigation process to look to see if the conduct is inappropriate and can be addressed before it gets to the level of being unlawful. In 2014 through 2016, we did a concerted effort to review the anti-harassment programs at each federal agency under our jurisdiction. We actually have jurisdiction over probably a little bit over 200 federal organizations of different sizes to determine if their anti-harassment programs were effective. The factors that we looked at to determine effectiveness were whether the policy is conducted separate from the EEO process, its placement within the organization, the extent to which it's utilized and known by their employees, and 4th, whether the agency has a tracking system to see trends that's going on within their workplaces. After this 3-year review, we found that many federal agencies, the vast majority, still have ineffective anti-harassment programs, generally because they're missing essential components or it's not adequately implemented or known by their employees. Our general finding when we're looking at all anti-harassment programs were those that had the effective programs, like the one you're going to hear from NASA later on, had the lowest complaint rate in the federal government. Finally, in terms of preventative measures, EEOC is invested in providing training to help organizations understand how to prevent harassment. We have 2 training modules that we created in 2017, Leading for Respect for managers, respect in the workplace for all employees, and it goes beyond traditional anti-harassment training. It really goes to the cultural behavior that leads to incivility in the workplace and how to address that before it becomes actionable harassment. In conclusion, harassment, including sexual harassment in the workplace, remains a persistent problem in the workplace. Federal agencies have made some progress in addressing anti-harassment, but there's still much work to be done. EEOC looks forward to working with this commission and the larger federal sector community to address these issues. I thank you for this opportunity today and look forward to your questions.
Thank you, Mr. Brooks. Chandi?
Good morning. My name is Sunu Chandi. Before I read my remarks, I want to say thank you to this commission for recognizing the human impact of these issues and having mental health support available. I also want to say thank you for recognizing that whether you come forward or not, it's a corrosive impact on your life. Either choice is hard, so thank you for acknowledging that. My name is Sunu Chandi. I'm the legal director at the National Women's Law Center. I appreciate the opportunity to provide testimony regarding measures we must implement to help make the federal government a more inclusive workplace. I want to thank all who contributed ideas for these remarks, including former EEOC Commissioner Hy Feldblum, my co-panelist Dexter Brooks, and a number of attorneys who have deep expertise representing federal workers. including Deborah D'Agostino of the Federal Practice Group, Jennifer Clark with Relman Dane and Colfax PLLC, and a final thank you to the National Women's Law Center intern Lauren Hoffman for her diligence in helping to prepare these remarks. The federal government must be a model employer when it comes to eradicating sex harassment and indeed all forms of discrimination. At the outset, it must be noted that federal employees' civil rights protections are far less favorable than in the private sector. This is particularly appalling given that there are tremendous gaps in the protections facing employees in the private sector too, and these are currently being corrected in the Be Heard in the Workplace Act. This act includes requirements for additional studies and reports concerning harassment, specifically in the federal government, and importantly extends the time for filing complaints in the federal sector to match those proposed for the private sector, as I will discuss. By way of background, for most of my 20-year legal career, I've worked in the federal government as a civil rights attorney and leader. First, I was with EEOC's New York District Office for 15 years, primarily as a senior trial attorney. At EEOC, I experienced firsthand the need for additional resources so that EEOC can adequately fulfill its mission, which is critical for all stakeholders, including workers and including the employer community. When I served a detail as a supervisory investigator, each person on my team carried over 100 charges of discrimination. And I too had 100 charges that were yet to be assigned that were brought to my office when the former supervisory investigator retired. I provide that example to make crystal clear that it is only through increased staffing that EEOC can properly fulfill its mission. More recently, I served as the Deputy Director for Civil Rights at the Department of Health and Human Services until August 2017. While leading the HHS Civil Rights Division, I had a team of about 20 individuals, including 3 section chiefs. This team both provided input on systemic investigations in collaboration with the field and also developed policy to address discrimination in healthcare and human services. In this role, I had to address complaints as a senior manager and also ensure that my own managers were well equipped to address issues that arose in a competent and timely manner. In August of 2017, I joined the Nash Women's Law Center. The center was founded over 45 years ago and takes on precedent-setting cases, advances new policies at the federal, state, and local level, and uses research to build support for transformative changes in women's lives. We work on workplace justice, education, health and reproductive rights, income security, and childcare. At the center, I oversee our litigation efforts and also help to build the Time's Up Legal Defense Fund. I also provide guidance for our workplace equity policy and recently provided congressional testimony in support of the Equality Act, a bill that would strengthen and clarify civil rights protections, including for LGBTQ individuals. In thinking back about the importance of EEOC's work in the federal sector, one of the major highlights while I was there was the opinion in Macy v. Holder in 2012, as this decision made explicit that claims of discrimination based on gender identity are included as part of Title VII, the federal law protections against sex discrimination. And in 2015, in Baldwin v. Fox, another federal sector case, it decided that a claim of sexual orientation discrimination is necessarily a claim of sex discrimination under Title VII. Through these cases, EEOC provided critical guidance as to the scope of federal protections against sex discrimination. And now, as the Me Too movement has illuminated, many sexual harassment claims also include intersecting forms of discrimination. As such, the changes I'm about to recommend are not limited to sex harassment, but must be implemented across all areas of workplace discrimination, so that as women of color, immigrant women, LGBTQ individuals, and others who face discrimination do not have one set of procedures and rights for sex harassment and another, likely lesser set of protections as women of color. Our recommendations are as follows. First, there are 2 changes that might require larger statutory or regulatory changes. 1, protection for all workers, including independent contractors, unpaid interns, and volunteers who are currently left out. 2, we must extend the current statute of limitations. As noted, in the private sector, we have 300 days or 130 days, which is still far too short. In light of that, for federal workers to have 45 days, and then if they engage in an informal process to have 15 days, and otherwise they lose their claims, is completely appalling. The next changes are ones that can be implemented more immediately. One, leadership from the top. Given the role that senior leadership has in setting the tone, we have a problem. The President of the United States has not engaged in building a culture free from sexual harassment, indeed to the contrary. Given this backdrop, other federal leaders must foster an organizational culture in which harassment is not tolerated. The other areas that I have detailed in my written testimony include stopping misclassification of federal workers as independent contractors, so then they don't have their rights, resolving claims more quickly through triage, and ending confusion that stems from having parallel processes through one harassment office, one EEO office. We also need required and effective training. In this moment, it is extraordinary to live in this vibrant cultural time that will redefine how sexual harassment must be addressed. We call on the Commission to push federal agencies to meet this moment and to make these really critical changes. Thank you for having us.
Thank you. Mr. Tusi?
Thank you, and I also, want to thank the Commission for inviting a sole practitioner, not a sole practitioner, but a lonely practitioner. I get to deal with the EEOC on a daily basis in my practice. I represent primarily federal employees. Commissioner Adibale, what you said something that I want to expand on, and that is, you said harassment thrives in a particular environment. In my experience, and I've been doing this for over 40 years, harassment survives because the harassers are not sufficiently punished. In my experience, harassers and discriminators do what they do because nobody stops them. And people who look on, their colleagues, understand that there are certain things they can get away with without being adequately punished. And just as observers look at somebody who's retaliated against for complaining and decides, I'll skip it, people who look at harassers get away with what they get away with feel that the threat is insufficient to deter them from doing what they do. Expanding on what Mr. Brooks said, the EEOC has two roles. One of them is the complaint process and the other is adjudicative. One of the difficulties with the system that I work in is that it's the agency itself, the agency whose employee has done allegedly the discriminating or harassing, that has control of the first part of the process. The complaint goes to the agency can dismiss it, the agency tries to shift the claims in a way that is not as harmful to the agency, and if the employee still persists, ultimately the agency gets to investigate the complaint. And the investigative report shapes the way the rest of the allegations move forward. The second aspect of what the EEOC does, though, is they issue decisions. And I pointed out in my written statements a series of decisions that I think were extraordinarily sensitive in the area of sexual harassment. And I want to go over them just briefly. The first is a case called Tammy S. These are all pseudonyms. Tammy S. was an EEO specialist. She did training and was subjected to harassment in the form of a website that somebody at the agency started to harass her. And at one point, she was the subject of a cartoon in which a weapon fired phallic-shaped missiles at this woman. The perpetrator was eventually suspended, but when he came back, he continued with the harassment. Tammy then complained. The agency dismissed the complaint. They found that the harassment was not shown because they took prompt and effective suspension of the perp. The EEOC reversed that decision on the ground that obviously whatever they did to the harasser was not effective, and therefore the agency was not entitled to the affirmative defense which the Supreme Court had set up for them. The second case is Celine B. From 2015, in which a female employee was subjected to harassment in the form of touching and comments over a 4-day period. Her colleagues were so concerned that they would not allow her to be alone with the harasser. Nevertheless, the agency found no harassment because she didn't complain soon enough. The EEOC reversed that decision, and this is another stunning decision, in my view, from the EEOC on the ground that she complained, and therefore the affirmative defense of failure to protect herself was not available. That this is an earth-shaking decision. In Complainant versus the Army, this was a summer intern who was kissed during her last week, kissed and really sexually harassed. Again, the agency found no discrimination because the harasser denied it. And the employee, when she was subjected to harassing comments a month before, didn't complain. The EEOC reversed that decision, finding that there was enough evidence of the harassment, and in another remarkably sensitive decision, found that frequently women will not complain about comments because they think if they just grin and bear it, they'll go away. And the EEOC said, no, we understand that. There's another decision that I didn't mention in my written remarks called Margaret M., in which 3 separate women, employees of the Postal Service, complained of sexual harassment by the same manager. The agency found no discrimination because the employees missed a particular time limit in filing their administrative complaints. The EEOC, once again in a really remarkable decision, said they would exercise its authority and forgive the time limit violations and send the cases back to the Postal Service for adjudication as a consolidated case involving this particular manager. What's amazing about all of those decisions, as good as they are, is that they were all rejected by the agency. The only way they get to the EEOC is because the employee brings it to the EEOC. And to me, that's a serious problem. I don't want to let my time go by without saying that my firm represented 564 employees, female employees, at the Coleman Federal Corrections Center, who filed a class action because they were subjected to sexual harassment by inmates without being protected by the agency and by their managers when they complained.
Thank you, Mr. Chusey.
Thank you.
I'm going to open for questions and comments from my fellow commissioners. Mr. Degley, do you want to start us?
Good morning. Thank you for that very thoughtful testimony. Ms. Chandy, we've heard that the objective of the federal government is to make the response to sexual harassment be a model response. And I just want your views about whether, under existing experience, we're meeting our aspiration as the United States.
Thank you. I think the examples that were just given highlighted the ongoing and continued problem. When my co-panelists started talking, the first thing that came to mind for me was conflict of interest in terms of sort of the current process does not seem to be set up in a way that the employee has an advocate. I mean, maybe if the individual has an attorney, that is different. But to have to navigate sort of all of these parallel systems, and that's the issue that came up again and again when I spoke to attorneys who represent federal workers. There are parallel systems that are not clear to employees. There is a separate harassment office, which is funny to me because harassment is a type of discrimination. But putting that aside, there's a separate harassment office and it sounds like it was well intended to provide an alternative route that may be less time consuming and more informal. So it sounds like a good idea. But if you go to that, through that process, And meanwhile, your 45 days are ticking, gone. And you've now lost your civil rights protections in the workplace because you are attempting to do what I think we all agree is a good thing, to resolve something in a timely way, in an informal way, and which is absolutely of benefit to federal agencies in terms of liability and everything else. So if that process is going to continue, we must have a way that your formal complaint timeline is told while you go through these informal mechanisms. Without that, there's no way that I would be in support of these parallel structures. And I think that kind of tolling is firmly within the rights of the agencies to do, and it is to everyone's benefit. Because if the actual complaint timeline is told, maybe more people will use the informal system, which could lead to more timely resolutions, which is better for everyone. But the current system with only 45 days, with parallel structures that are not clear, and then I heard if you go to the EEO office and they work with you on it and they try to resolve it, but your complaint is not filed, then they give you a notice that say you have 15 days to come back and file your complaint. And then if you don't, you lose your civil rights protections. So that is what I understand to be the current system, which seems to be weighted incredibly against access to justice for federal workers.
Thank you. Mr. Brooks, could you help us understand what the current status is of protections for interns and contractors under federal law, and whether it's the position of the EEOC that those protections are adequate?
I don't know if we have a position on the adequacy of the protections because they're based in law. So the law says, in terms of our law, it protects employees. So there's a definition of employees. So we have two seminal cases where we define how a contractor can be an employee using a control test. Using a case names, one is called MOB versus HHS, and we lay out what's necessary if it's a contract employee to have the agency to have enough control for us to deem them to be an employer. But we have to deem them to be an employer before we would have statutory authority over the organization. So we have a whole line of cases for independent contractors. Interns are a little more vulnerable because of their employment situation. It's pretty much laid out that they're not employees. But we have had cases where we made findings that interns, independent contractors are employees, in particular where the agency exercised exceeding control over their working conditions.
So essentially, what I'm hearing from you is because of the statutory definition, there are difficult questions to be resolved about whether protections are available or not available. But none of us doubt that contractors and interns are both susceptible to discrimination and could fall outside the protection of federal law. Do I have that right?
Yeah, interns is tricky because you can have a paid intern or unpaid intern, they're employees. So I should clarify that. The independent contractors is the trickier issue. I mean, we've had many cases where interns have filed cases. I didn't know if George was going to miss. We had a case where an intern was raped over a summer within the Department of Defense. She didn't come forward because it was embarrassing. She was a teenager. The reason her parents found out is she became pregnant, and they asserted to the agency that this has happened. And you know, the initial kind of is she's an employee, and of course we said she is an employee. She was a summer intern under the control of the agency, and this happened, and we provided some remedies for her in those situations. So interns, paid and unpaid interns, are generally covered under our law. The real tricky area is independent contractors, and so we use that control test for independent contractors.
Ms. Chandy, it looks like you want to get in on this.
Just to make a point about independent contractors, there are two issues. One issue is that under the current framework, independent contractors are not included in the law. So that is a statutory change that's necessary. But there is another problem that I witnessed firsthand, which is people who are working side by side with federal workers, doing the same job, being controlled in the same way by the employer, are misclassified as independent contractors, which is a separate issue that we can fix immediately, which is to say these factors that are supposed to be looked at are not looked at, and instead what's looked at is who is providing the paycheck. We all know, if we've been in federal service at all, the benefits of having temporary workers. There's more flexibility. It might be easier to do the hiring. There are a whole host of reasons why there are incentives to do this. But the harsh outcome for those individuals is that they do not have civil rights protections from the federal government, even though they are working side by side with federal workers who are doing the same job. They're controlled in the same ways. Their day-to-day work is the same. That is not an issue that needs statutory change. That's an issue that needs oversight and for these factors to be applied correctly.
I understand Commissioner Yaki has a question.
Could I just, I think the concept we're talking about is joint employer status, where the federal agency, although not paying the paycheck, nevertheless provides the equipment and the management and the resources. Those employees, even though they're contractors, those individuals would be classified as joint employees of both employers and could file an EEO complaint. The difficulty is, I have not yet found an agency that would come to that conclusion on its own. They will instead classify the employee as a contractor, and only on appeal will the EEOC say, no, they're actually an employee.
Congresswoman Spear.
I would just like to comment on the unfair advantage that the harasser has over the harassed. Because typically, certainly it was the case in Congress, the House counsel represented the office of the member and the victim was on their own. So one of the changes we made in the law was to provide representation to the victim. We're also doing something similar in the military with sexual assault cases, where there's a special victims counsel available to the victim to help them through the process. So if we could provide SVCs in the military for the 1.3 million service members we have, we certainly could create a SVC program in the federal sector to provide counsel to those who are sexually harassed or assaulted.
Thank you. Commissioner Yaki, I understand you have a question?
Yes, this is for the Congresswoman. Congresswoman, thank you very much for your leadership and your personal courage on this issue. I wanted to ask a question that sort of goes to your proposed legislation, but in a slightly different tact. I think that what we're finding here and what you'll hear in other parts of testimony from other panelists today has to do with Congress can pass laws, or states can pass laws, or departments can administer policies, but the question is whether or not how it's actually being carried out. And in that respect, I'm looking toward the issue of oversight and accountability. And I'm wondering if in your legislation for the State Department, you are putting in some provision that would require the State Department, or for that matter, any other administration agency, a requirement to comply with information requests, oversight appearances, etc., to monitor and follow up and provide adequate oversight on the implementation of laws or policies regarding sexual harassment. And I say this, with an eye toward the current context in which we exist, where the Commission has encountered, and I know the Congress has encountered, difficulties in getting information from the administration and ensuring that the oversight responsibilities of the Congress, or even for that matter the Commission, are not only enunciated in law, but have adequate teeth and, for lack of a better word, compulsion in order to get the information needed to provide the kind of oversight and scrutiny required after laws or policies are in place or enacted.
There are a number of elements in the legislation, but I think the two that kind of hit the issue that you're attempting to address is the requirement that there will be to have climate surveys. We already require climate surveys in the military, and it's a profound way to measure whether or not we're making any improvement. We've just come out with the sexual assault review, and it shows that the numbers have actually increased. So having climate surveys, making them permanent, will have, I think, a very effective way of doing that oversight. The other aspect in the bill that is also very important is transparency. If you basically settle cases and then no one knows about it, then the perpetrator oftentimes can continue to conduct themselves in a manner that is violative of the law. So this particular bill would require greater transparency around disciplinary actions. Again, in the congressional legislation, we're requiring that every 6 months, in which there will have to be a posting of the cases that have been resolved and whose offices they are and for how much money. Mr. Brooks?
Thank you.
So I just want to add that working with the House and House Oversight Committee, they also passed a bill back in February that's still with the Senate. And this is the second time they passed it. It's a revision to the No Fear Act, the Notification Federal Anti-Discrimination and Retaliation Act. And the House has put in there great measures for, it's not focused on just sexual harassment, but all discrimination and retaliation, to make things more transparent in terms of the actions taken by the agency to address discrimination. Because one of the statutory limitations we have in the EEOC, we can't punish a management official. We can remedy the victim. We can provide make whole relief to the victim, but we don't have punitive authority to say fire, terminate, demote that employee. And so the House in particular, and the House Oversight Committee, has been working to try to find ways to create greater accountability. And I would encourage folks to review that legislation that was passed, because it could also be a vehicle that's helpful in the area of sexual harassment.
Thank you. Commissioner Arasaki?
Thank you, Mr. Brooks. Actually, that's one of the areas I'm very interested in. The research is shocking, that the amount of retaliation that happens, and it seems to be one of the largest reasons why, understandably, people then choose not to report. What can be done? What are your suggestions about what we could be recommending could be done to try to get at this issue of retaliation?
So I think it goes back to what I was just talking about in terms of greater accountability and transparency. So if a management official is not worried about what the ramifications are, there's no dissuasion from not repeating the conduct or enhancing it. And so that's one of the critical things that's missing in this equation. So we were very pleased with and happy with what the House was proposing in terms of revisions to the No Fear Act. Some of the other things that we've been trying to do within our scope of our authority of oversight and guidance, one of my researchers is here, and we have a social science wing, and we've been helping agencies understand the behavioral science behind discrimination and how to address those things. We've worked with some management groups, the Federal Management Association, to really share with their team why managers retaliate and how it's disruptive to your organization. It's not just illegal, but allowing it to happen is detrimental to your mission outcomes. So we try to take the approach that it's wrong, but we're also taking an approach from our guidance area that is also detrimental to your organization. So those are some of the strategies that we've implemented recently to try to address retaliation.
Does anyone else have specific ideas?
I don't have an idea, but I have a stunning example of what happens. We represented a female employee at one of the correction centers who was raped by an inmate, and which is much more common. The harassment by inmates is much more common, I think, than most of us appreciate. She immediately complained to her manager, the warden, who promptly contacted the U.S. Attorney's Office and encouraged them to file charges against her on the ground that she had actually raped the inmate. And the U.S. Attorney's Office pursued criminal charges against this female employee. It took the jury about an hour to find her not guilty. But nevertheless, who in that facility is going to raise another charge? Not likely.
I would just add, as a litigator for many years, the retaliation claims are the easy ones. And perhaps there needs to be training of management officials and supervisors about how that claim proceeds. I mean, just from an employer-friendly business model, you need to have your managers and supervisors know that any sort of negative action that they take in response to a complaint, often the timing is very clear. The range of conduct, this is an area where courts have been very expansive, surprisingly, and what retaliation means is very dependent on the workplace. I litigated a fast food industry national case for many years, and the retaliation was you have to clean the bathroom every day. Now, that obviously would not be relevant in many of our office settings, but that's the power they had over you. And if you brought a complaint, that's what happened to you. I've had cases where managers put out leaflets in neighborhoods saying that the women who came forward were child molesters and put them on people's cars. And the employer argued that's not retaliation because it wasn't in the workplace. And fortunately, the court got it and said this is severe action that would discourage people from coming forward. So I think maybe having some real clear training of managers about the scope of retaliation. And as a manager, the only thing you should do if someone comes forward is say, thank you for raising this. Let me get in front of this. Let me handle this. That is a benefit to the organization. And fortunately, I think in the Me Too moment, some HR offices across public, maybe public sector too, but definitely in the private setting, are being more transparent and are saying, this issue came forward, this is how it was handled, to let everyone know it was handled.
I just have one more question for Mr. Brooks. So I understand that your office has oversight authority over EEO programs. However, my also understanding is that EOC does not have an enforcement mechanism if, for example, it disagrees with how an agency's EEO program operates. Is that correct?
Yes.
So does EEOC have enough resources to effectively monitor all EEO programs of federal agencies? And if it doesn't, how much more does it need? And would the ability to have enforcement mechanisms, if you disagree with how an agency is conducting it, be helpful?
So in terms of resources, I don't think any federal agency would say they need more resources. So I would say, yes, we would leverage resources and provide even more oversight. We do as much as we can with the resources we have. It was fortuitous that this week we do technical assistance with each federal agency, and we come out and meet with them to go over their EEO programs. Just so happened we met with the U.S. Commission on Civil Rights on Tuesday as our oversight to look at your EEO program. And so we try to do the most with the resources we have in terms of addressing issues. So of course, with more resources and more ability to manage data and help agencies track trends, we could be more real time, because a lot of things that we address now really deal with bad actions that's already happened. It would be ideal for us to be able to have access to data and trends so that we can fire a hotspot. This is the type of occupation that has isolation and things that went on, and we want to do a review. We just don't have that ability to do that in our current resource. The Congress and the President were generous with us the last 2 years to increase our budget to address sexual harassment. And so we've been leveraging the additional resources to actually come up with strategies. That's why we were able to spend so much time with federal agencies focused on anti-harassment programs and over the last few years. I don't know if I answered all your questions.
Thank you. Mr. Patton?
Madam Chair, I'm going to have to excuse myself at this time, so.
Can I ask
I'm
you-
going to ask you my question then. Can I do that?
I want to ask her my question.
Mr.
Steve,
Patton will ask, and then I'll ask him. We'll hopefully squeeze in
Thank you,
time.
Congressman, for staying. Appreciate it. We did a report on sexual assault in the military several years ago, and I was wondering, a simple question or complex, actually, I guess. The numbers are up. I saw that in the paper the other day. Are they up because the military encourages reporting, or are they up because sexual assaults are up, or are they up because the military really, some aspect, not really, but it's in many aspects changed and encouraged more reporting.
So they have encouraged more reporting. We have thrown a lot of money at the military for this issue. I think over the last 10 years, we've spent $200 million. And the truth of the matter is, none of this is working. Now, for a long time, I have proposed taking these cases out of the chain of command, keeping them within the military, but a separate office that would have the skills to do the investigations and the prosecutions, and that would be independent, because there is an inherent conflict of interest that exists. Either the chain of command has the perpetrator in it, or is good friends with the perpetrator, or is concerned that it will reflect poorly on them for their next promotion if they have sexual assault cases under their command. So it continues to plague us, and the cases are up. What is stunning and people don't realize is that the climate surveys show that about 20,000 cases a year, only 5,000 report. So that fear of retaliation, I think, is very serious, and that's why you have only 5,000 in the report. And of the 5,000, only about 500 go to court-martial, and only 250 are convicted. So, there's a very strong message that goes out that why bother?
Well, I would encourage you to continue fighting for the prosecutorial and investigative separate office. That's very important. Thank you.
Mr. Clavin, I promise to come back to you with your other
Yes,
question.
thank
But before you leave, Congresswoman, I wanted to ask really two questions. One is, given all you've seen about federal sector sexual harassment, could you talk about what caused you to focus your legislative efforts this year on State Department? What was so concerning there? And then before you answer, my second question, just so I don't lose it, is in your experience, what are the elements that are most effective for redress for sexual harassment? Obviously, you put a lot of thought into that for your fellow members of Congress and had real teeth to your most recent legislation.
So my positions really are formed in part by what we've done in the military. So I think that climate surveys are a must, and we should basically require them, particularly in all of the departments where there are occupations where you have remote or isolated kinds of environments. That happens a lot in the Department of Interior, National Park Service, Fire Service, Department of State. There are probably others that don't come to my mind at the moment, but also should be subject to that. And the transparency component, where you create accountability in some respects by focusing in on under whose leadership it took place, what kind of action was taken, and make that public. The reason why we are focused on the State Department is first and foremost, I guess, they came forward during the Me Too movement and focus within Congress and had over 200 or so signatures. And then we met with them, and you could see why there is a need for greater accountability in that department. That's not to say there aren't other departments that require the same kind of a close review and measures put in place for greater accountability.
Thanks very much, and thank you for your time. We really appreciate your testimony. Mr. Claddy?
Thank you, Madam Chair. In a past lifetime, I was actually a labor lawyer. I find it interesting when you talk about discipline, talked about the suspension of an employee. Most government agencies, all government agencies, I think, through union contracts and things like progressive discipline, a warning, a written reprimand, suspension, a longer suspension, a termination type of thing. In your experience, and I would probably address the whole panel with this, in your experience, what type of discipline actually fixes or cures or stops or creates an environment that is okay? where there's someone who's a sexual harasser?
Well, one of the cases I mentioned, I think it was the Margaret M. case, which was decided just last year. In that case, and I think one of the things that persuaded the EEOC to forgive the timeliness problems was the fact that there were 7 other women who were subordinate to the same manager who had told people about his harassment of them. Frankly, Commissioner, I think the only way to get rid of that is to remove the manager. Now, he's in the Postal Service, which is not exactly the same as the rest of the Title V civil service. But nevertheless, when you have someone who feels as free as he does to engage in the conduct that he did, I think the lesson for everybody else is to fire him.
Former life, I was also a labor lawyer representing union side employees and unions.
Congratulations for surviving.
I may have a response that is surprising, but the National Women's Law Center and myself, we believe responses should be proportional to the conduct at issue. It should be for the most severe conduct, the cases that my fellow panelists mentioned, yes, they do sound like cases that should require termination. But the concern that I have is that often in the public sector and the private sector, we see transferring harassers from agency to agency, location to location, as a common way of addressing the problem. And it is not effective, and it creates harm across many, many workplaces. So that is my number one issue in sort of how issues are dealt with. I don't think people should lose their jobs if they tell a sexual joke. That is not appropriate. Someone should be counseled. There should be a record. There should be warnings. It should be proportional. And let's bring up the racial implications. Who's going to be more likely to be disciplined or not disciplined often has racial implications. All of these pieces must be looked at holistically in coming up with a system to address complaints based on the seriousness, based on, are there repeated complaints, based on, are there multiple people who come forward, right? So all of these elements must be considered together, and we cannot have an easy answer of save people's jobs or fire everyone. This is important to be nuanced and to consider all the equities. But at the end of the day, the workforce must know that the issues will be taken seriously, and the employee who brought the complaint must be informed about what happened. Sometimes with EEOC, someone would file a charge saying, I made a complaint and they didn't do anything. And then the employer would say, like, here's the 6 things we did secretly, never even got back to the person about any of it. Maybe you don't have to give all the details, but you should at least say the broad outline of what happened and say, please come back to us if this starts happening again, and have that monitoring.
So the question I have, I mean, I understand proportionality, discipline. Is anybody taking this up? Is anybody, I mean, you talk about it in rules and regulations, okay? But is anybody taking it up in training? Is anybody actually inoculating the managers about how to perform discipline? I mean, I found years ago when I did this work, that was the last thing managers learned how to do. They ever learned how to do it.
Yes, I would agree that training is critical. I would also say that unions have a greater role to play. There are many examples where if you bring up a wage issue or another issue, the union gets on the phone, deals with it right away. Oh, let me handle this. But if it's sexual harassment, it's like, oh, find the special magic form that's hard to find, and so on. That is not an appropriate way. And I think unions also must and have been taking more and more leadership on this, because they're the ones in that interface and can help solve these problems too.
A long time ago, there was an effort to confer additional powers on the EEOC to do something about managers who are engaging in really difficult behavior. Um, At the time, we were advocating that the EEOC should have authority to refer such cases to the Office of Special Counsel, which does have the power to discipline employees for certain violations. I think that if that isn't done now, that really needs to be done. The Special Counsel is a separate agency. They have no quarter with personal friendships or anything else. And they are a fairly reliable protector of the merit system. And I think if they find somebody like this manager and Celine B., that case ought to be referred to them for an appropriate response.
So in terms of what my colleague just said, we do have an MOU with the Office of Special Counsel where we can refer from a management official for prosecutor, so they can prosecute against the individual manager. They have that authority, we don't. And we've had several MOUs. Most recently, we signed a new MOU a year ago. So we believe it's a real egregious case, and we don't think the agency did what's necessary, because once we issue an order, we always will recommend discipline, even though we don't have authority to order discipline. And then what we'll do is track what did the agency do. And if they didn't do discipline that we thought were appropriate, we have the option of referring it to the Office of Special Counsel. The problem in a lot of cases that we have now is the life of it. So by the time it goes through the complete administrative process and we're able to refer it to the Special Counsel, maybe 4 years have passed. And so now we're trying to find ways of how to get things more speedily to the Office of Special Counsel. The legislation I was talking about with the revision to the No Fear Act has a provision in there. Every finding of discrimination automatically would be referred to Special Counsel. House passed it in February, it's with the Senate, so that could be something as a mechanism. In terms of what discipline works, I agree with my colleagues say. In our select task force on the study of harassment, we said discipline should be proportionate, because sometimes if the discipline is drastic, harassers won't break it because I don't want the person fired, I just want the behavior to stop. And so really a conversation, what's missing in the equation, I think from my perspective, is there is not a conversation with the victim about what's appropriate and follow up with the victim. And there needs to be more transparency. I remember, I don't remember the exact year, but one of the surprising things from a federal agency, we had the CIA, they had put out a report to their agency. These are the harassment cases we had last year, and this is what we did, without naming people. And I always thought that was a real, if CIA can do that, why can't other agencies? So,
Secret.
yeah, because really what they wanted it to be is a deterrent that, if you engage in this behavior, we take it seriously and it could lead to termination and things of that nature.
Well, I have one more question in this regard. I mean, I asked about discipline for the harasser. What about the discipline for the manager that fails to adequately discipline? Does that ever happen?
On a related point, something that came up as I was looking into this was including how a manager addresses complaints, or whether or not there are complaints against that person or in that shop in the performance evaluation, and also as decisions about promotion are made. And so keeping those metrics and data so that it's really part of your record, how you address this proactively, how you address this if a complaint comes in, or also if you are the target of complaint. All of that is relevant information for if someone should, go up in the ranks.
Well, I think putting it on their evaluation is fine, but I think Mr. Cheesy,
Yes.
when he describes a warden as going to the U.S. Attorney's Office, that's more than an evaluation issue.
I was going to suggest that what the commission might do is ask the Justice Department how it is pursuing remedies involving the Bureau of Prisons. The Bureau of Prisons, it's a difficult job. They're difficult environments. The worst kinds of sexual harassment, because they're by inmates who are already being punished, takes place, but it's management's response to that. The Coleman case from the Coleman Federal Correction Center in Florida, 564 women, that settled for $20 million.
Congratulations.
Well, of taxpayers' money. And there was a companion case against another correctional center, not with our firm, but another firm, that settled for $11 million. Now, I think a real question is, what is the Department of Justice doing about that situation?
Thank you. I
Just-
understand that, oh, go ahead. Mr. Brooks.
Just in terms of the question of, I don't know of cases where the manager that inappropriately responded to the matter. I know in our cases, what we can do is we can't order discipline, but we order training. So if we see that the entire management team failed, we order that not only the manager, the harasser, but any manager that allowed it to happen for their inaction or failure to intervene in the situation, we order training to that whole management team to try to provide some remedy for the employee.
Well, I personally think that there should be some discipline, because the manager should already be trained in this. I
Okay,
mean,
we're going to
that's part
keep
of being a
moving. The other
manager.
commissioners. Madam Vice Chair, I understand you have a question.
Thank you, Madam Chair.
Yes, are you able to hear me?
Yes, thank you.
Okay, yes. This question is for Mr. Brooks and any others that might want to answer, but in thinking about your oversight function, I was wondering how important is the self-reporting by the federal agencies, and what is it that you do with this data, and whether there may be some way that the self-reporting can be strengthened or in some way helping us get to where we want to be.
So agencies do self-report. They have to submit 2 reports to us annually. The first report is a summary of all their complaint data that happened in the prior fiscal year, so that we can see, what are the issues basis and the timeliness indicators within the different segments of their processing of the complaint. Then the second report is on their workforce demographics, looking at race, national origin, and gender by their major occupations, discipline, training, and things of that nature. And it has a self-assessment part to it where they have to answer yes or no. And every time they check a no, we consider it a programmatic deficiency that we follow up on. So what we do is they certify it. They certify that everything that they report to us is accurate, is signed by the head of the agency and the EEO director is true. But then our staff, who are more familiar with the requirements, will go through all the data. We visit agencies on site usually every 3 years, and we'll look at 3 years of trends to see, what were the number of harassment complaints. Was the number of harassment complaints above the government-wide average? And if they say that they have an effective program, then we'll say, well, why is your harassment in terms of complaints higher? And then we'll look at different demographics, anything that comes out in the public, like I know the Congresswoman mentioned the Forest Service, the Park Service. We track what's going on there. We have robust correspondence that comes in from individuals that's concerned with things at their agency. So we have a repository of data on each agency. And so when we have an opportunity to do our technical assistance and feedback, we will bring those things up. Now, if they're consistently we find that they're not reporting correctly or they're not making progress, our next step is we do what is like an audit. We call it a program evaluation. We have an audit function where we go in and we do a more aggressive type of IG look with recommendations and things, and we put them in a compliance plan to monitor what they're doing. We can't force them to do it, but we stay on their cases. I mean, Mr. Chusey's brought up Bureau of Prisons several times. Bureau of Prisons, I don't know if he knows, but we did detailed evaluation of Bureau of Prisons because their retaliation rate was well beyond government-wide average. So we visited several of the penitentiaries and interviewed staff and made recommendations for Bureau of Prison. And they made some progress, but they still have a long way to go. So in sum, we use all the data to try to inform us about the organization, how to improve them. Each agency is different. They're unique. Our largest federal agency is Department of Defense with over 800,000 employees. Our smallest federal agency is the U.S.-Japanese Friendship Commission with 4 employees. And so you have everything in between. We have federal grocery stores, DC, which is Defense Commissary Agency. We have NASA, where you have federal employees in space. So there's no one size fits all. We will work with each agency as an organic creature to figure out what's going on within their organization. That's how we kind of use the data.
Ms. Chandy?
Yeah, on the
Thank you.
idea of reports and studies, I just wanted to lift up that in the Be Heard in the Workplace Act that I mentioned, Section 112 is about study and report of harassment in the federal government. And it calls for the Merit Systems Protection Board shall prepare and submit a report about harassment in the federal workforce 1 year after enactment of this act and every 3 years, and funding for that. And section 113 is also about studies, reports, and further research, and calls on the U.S. Commission to undertake certain programs too. So in addition to the extending the time frame for filing complaints, as it relates to federal workers, there are other provisions in the Be Heard Act relevant to the federal intentions.
Thank you. Mr. Brooks?
I just wanted to highlight, because I have one of our social scientists here, and we're looking at it from other areas. She's behind me, Karen Brumman. She's done some real good work looking at sexual harassment, and we've been putting out more guidance and reports to agencies. She did a nice report on learning from the way community policing has changed behavior. Because you're really trying, how do you change the behavior and culture of an organization? I mean, we can remedy discrimination after it's happened, but why do you want it to get to that point? And she put together a real nice piece on the broken window principles of policing. If you have a community where you see broken glass everywhere, you're more likely to have more serious crime. Why wait till you get to that point? Giving federal agencies some recommendations to look at incivility that leads to inappropriate behavior. Actually did some research on one of the things that we often do in this process. If there's a victim of sexual harassment, we isolate the harasser and the person who engaged in the harassment, and there's never a conversation after that traumatic event. And should there be a conversation, they're going to go back into the same workplace, and should they have a conversation, should the accuser be able to say, this is what you did to me, this is how it made me feel, and we're going to continue to work together. We don't do that. We put them off. This person, you work this shift, you work this shift. You don't come past this hall, you don't come past this hall. And it creates a division within the organization. Should we be looking at a way to find a way to remedy those situations where they can, if they're going to coexist in the organization? So our social scientists have been looking at a lot of the behavioral aspects to give even more information to agencies versus enforcement.
Mr. Brooks, would you mind submitting that report for our records so that we have it for review?
Sure.
Thank you. And I take it from your last answer that you view that kind of reporting guidance to agencies as an important enforcement tool for the EOC. Is that right?
Yes.
Thank you. Madam Vice Chair, sound like you had another question?
No, Madam Chair.
Great. Then I will go to mine.
And you're breaking up. I don't know if it's on my end, but you've begun to start breaking up.
I will lean closer to my microphone. Thank you. Mr. Brooks, you testified in your opening testimony about the value of systemic enforcement, and I wonder if you could expand on that. I have heard you speak painfully about the need for more resources for EOC and what you would do if you had more resources. But I take it with the resources you have, you and your colleagues have chosen systemic enforcement as one important mechanism for the work that you do. Can you talk about why?
So in the private sector, and I know Ms. Chan, she could talk about some of the work we do in the private sector. We really try to bring strategic cases in the private sector that sends a message across industry. So, we had issues with pregnancy discrimination in restaurant industries. So we brought some high profile cases to show, when a person became pregnant, they lose their job. So we try to highlight those cases, the inequities in law firms. So we'll bring lawsuits. So strategically, we have units across the country that will work together collaboratively to bring nationwide lawsuits that send messages in the private sector. In the federal sector, we try to compile all the data that we have to see what are the systemic trends going on in federal agencies and then highlight them. So we can see that retaliation is, a huge part of our inventory. So we can put resources on studying retaliation, coming up with some behavioral models for agencies to use to address those issues. So in terms of our strategic enforcement, it's very much on the litigation side. We try to take cases that can be precedential. My colleague mentioned the 2 cases on gender identity and sexual orientation that we issued in the federal sector. And so with the cases and the data that we have, we try to leverage it to provide information to the employers as a whole.
Thank you. And Mr. Chusey, your testimony mentioned difficulty in having to wait for agency review first before being able to go to EOC. I wonder if all 3 of our panelists could speak to your views about that. Mr. Brooks, do you value having agencies review first? Is there another process that you think could work equally well or better for EOC? Mr. Chusey, Ms. Chandy, in your experience, is there some alternative or is the benefit of the agency review first worth the wait?
I have long believed, I'm not sure there's an alternative, but I have long believed that giving the agencies the first crack at this is just the wrong thing to do. I understand why they did it. Agencies have to bear the burden of these costs. If they didn't, those costs would be shifted to perhaps an independent agency, which might be a better solution. But what it is, you know, and people have, for 50 years, they've said it's the fox guarding the chicken coop, you know? And I think the reality is virtually every case, agencies are allowed to appeal sometimes too, but virtually every case that the EEOC gets on appeal is a case that the agency has turned down. Or they've gone to an EEOC administrative judge who has turned it down. But the fact of the matter, every time the EEOC rules in an employee's favor, I see that as a failure of the system, because that should have been found earlier. And people, you know, my firm charges for our services. And there are people who start off and they're really eager and they get to a point when they just run out of resources. I have a client now, and I'm going to talk to Mr. Brooks about it. The EEOC just issued a decision in this month. His case started, it's got a 2009 date on it. And he was just he's a postal service worker. We had to carry him. We carried his attorney fees because I felt strongly about his case. But it's just extraordinary. I mean, who's got the resources for a 10-year legal battle against the United States of America, essentially?
Madam Chair, can I just have one follow-up on this question that you've asked?
Sure, but I want to make sure that the other panelists also can answer. So yes, you can follow
Okay.
up. But, no, go ahead.
Take the other answers first.
Thanks.
I think a couple of things. One, I liked what the Congresswoman had to say about ensuring that individuals bringing complaints have advocates. I think I mentioned that earlier too. It's really lopsided otherwise and unfair. I also want to lift up the Time's Up Legal Defense Fund because we provide attorney connections and even funding for individuals to bring these cases, because as was just mentioned, it's not free often, and usually workers are going in alone. The third thing I wanted to say was agencies, given that they are doing that investigation on site first, should triage their complaints and prioritize systemic or egregious matters for more prompt review. As I understand it, agencies are taking them in first come, first serve, which can seem fair, but actually these complaints run the gamut. And just as EEOC in the private sector triages the cases and deals with some more immediately, agencies must do that in-house as well if they are under-resourced in this area. And the last thing I will just say in terms of making the system better is bystander training, which goes to the larger point of changing the culture. I mean, if you're going to bring a complaint to HR in the private or public sector, most people do not feel like this is someone who will be on my side, but rather feels like this is someone here to defend the employer. And somehow creating a massive culture change where these complaints are welcomed and everyone is on the same team of having a safe and effective workplace, that work still needs to be done.
So I guess, you know, I've been at EEOC over 20 years. And so, you know, when I first heard the federal complaint process, you know, I had the same concerns that my colleagues would have. Like I since being there over the 20 years and seeing the way that it works, I kind of do believe the system in theory, because the theory is the federal government should be the model employer. And the model employer should address issues of discrimination without a need for a third-party intervention, such as EEOC or a federal court. And that we give them the tools to be that model employer. But we do have these issues when they have that authority to do their own investigation. We have the oversight authority to address that. We constantly, this system that we have in place for the complaint process predates the commission. It started in 1948 through an executive order. It was codified in statute in 1972 with an amendment to Title VII. And periodically, during the course of its history, we will ask the public, is there a better way to do this? Most recently, we put out an advanced proposed rulemaking in 2015 with that very same question. It said, we've had this system in place for over 50 years of the agency. doing the informal process, the investigation with the ability to have it adjudicated before EEOC. Is there a better system? And we didn't get many alternatives. The general alternative would be shift all the investigations to EEOC, and EEOC would conduct the investigations. But there's not a majority behind that. Agencies like having it. Employees are leery of putting that additional resource on EEOC. So when we got the responses to our latest advanced proposed rulemaking, there wasn't many tangible comments that would propose an alternate system. But they did give us recommendations for improving the existing system, and that's what we really work on. We work very diligently with agencies, EEO programs, and agencies' leadership to let them know that this EEO program should be a neutral program. It should be just like the EEOC within your organization, and it should, remove conflicts of interest where we're swaying to let's defend ourselves versus let's find out what really happened here as an employer and make our employee whole if there was something done wrong. And we constantly battle with agencies on that. They go, it's a constant. I think it's a natural reaction to defend versus to be open and transparent and run a neutral process the way EEOC. And that's what we've really been working with federal agencies on. How do you do the job EEOC would otherwise do within your organization? Because as a model employer, that's what's expected of you.
So just I'm trying to sharpen our understanding on this issue, because as I understand the way things go in the private sector, if there's a complaint to a company, the company in the first instance would take that up and do an investigation. Do I have that right or not?
There are many incentives to do that, because if you have such a process as a private employer, that can be used as a defense in court. So most companies have that, but it is not a legal requirement to go through any sort of internal process before one goes to EEOC to file a charge of discrimination. So that's how they're different.
So really what this comes down to, the complaints that we're hearing, does it just come down to having available to federal employees that disjunctive choice to have the option of going internally or to the EEOC right away? Is that what you're talking about?
No, federal employees do not have that choice. Federal employees must exhaust the remedy with their agency before they do anything else.
Correct. So what I'm asking is, what we're looking for in terms of a change, in terms of a remedy, is to provide that parallel choice that a private employee would have. And Mr. Brooks is saying there is some concern about the capacity and perhaps other considerations about whether the EEOC could handle a world in which that choice was available.
If the resources were shifted, right? I mean, agencies get resources for their EEO office to process EEO complaints. If those resources were shifted either to the EEOC, a separate sub-agency within EEOC, or another agency altogether, I think that disruption would be minimized.
Yeah, I mean, it would be shocking to me if there were employees' rights organizations that would be more in favor of keeping this in-house. I think at least having EEOC as an independent agency gives a sense of this is a separate organization that I might get a fair shake, which I don't think employees have when they go to their internal. Now, having said that, as Mr. Brooks said, every agency is different. There's some that might be having a very model process, but I assure you there are many that are not.
Madam Chair, I think I interrupted your questions for that clarification.
No, you can go ahead. If you finish, I have more, but
No,
I can ask some questions as well.
Okay, so Ms. Chandy, I want to come to this question of whether or not sexual harassment sometimes happens at the intersection of different types of discrimination, and whether the existing legal framework is adequate to prosecute and remediate situations where there is so-called intersections of discrimination occurring. Could you help us understand how it works and whether the current system is adequate?
The main point I want to convey is in this Me Too moment, many states, localities, or even the federal government are looking to improve their processes. And it would be foolish to do so only for sexual harassment when many of us face harassment that often even in the nature of the harassment itself, is implicating race or national origin or other areas of identity. And so it would be inappropriate and inefficient to say, okay, I'm now going to go and bring one complaint because I know this is about bias based on my sex, go to another office or procedure because this also has racial implications. Women of color often face harassment that is about both of these. People with disabilities sometimes face gender-based and disability-based discrimination that is intertwined. And so our call is for workplace procedures to be improved across the board and to use this Me Too moment to improve how employers deal with harassment, discrimination of all sorts, and have those procedures better for everyone.
Sorry, if a employee today complains about discrimination that's happening at the intersection, let's say, of race and sex, is the legal framework such that that those can be considered together, or must you be on different tracks?
Right now, in the federal law, they're on the same track, but in making improvements, we are saying that those should continue to be in a holistic sense and not just peeling off sex harassment because there might be the will to deal with sex harassment right now. We should not say, for example, for sex harassment complaints, you have 4 years. For race complaints, you have 45 days. You follow me? I also think because courts have not grappled with intersectional discrimination so often, I think plaintiffs and employees have not brought those claims in ways that have allowed that body of law to develop much. But I think there's a lot of interest in doing that because that is how we experience discrimination in our lives. And it's not simply saying, I have a race claim, I have a sex claim, but as a woman of color, I have a particular kind of claim, and that should be put more and more before the courts.
Last question, apart from timing resolving claims more quickly and this choice to be able to go directly to the EEOC, can you give us 2 things that the EEOC could do with existing resources? I clearly understand the point about more resources. We'll take that as given. With existing resources to come closer to being the model agency that we aspire to be.
Leaving aside the time delays. That's like saying, aside from that, Mrs. Lincoln.
So yes, right. No, the point here is that we have that point, but if there are additional things, I want to create the opportunity for things we may have missed. So we have that point. It's a very important point. I'm not diminishing.
For me, and I alluded to this in my written statement, I think the decision-making process at the EEOC, when they have their adjudicative authority, I think it has to be more consistent. I cited the cases of Tammy S. and Celine B. Celine B. has not been cited by the EEOC since 2015. And Tammy S. has not been cited by the EEOC since January of 2018. And to me, this is a concern because the EEOC comes out with what I think are terrific decisions, and where they go from there is anybody's guess.
Yeah, I'd just like to highlight, I put forth 7 ideas and only 2 of them I think require statutory changes. So just to quickly mention the others, one is the misclassification of actual employees as independent contractors, a review of that. 2, EEOC could tell agencies that they are allowed to triage complaints, so at least the more egregious ones can be addressed in a more timely fashion until there are more resources. Next, to end the confusion that stems from parallel processes and toll the complaint filing timeline if an employee goes through the harassment office or another office that is not the official EEO office. That is something that can be done immediately and I think would be for the good of everyone involved. And finally, to have more required effective training, including bystander training, which I also think will help the issues of retaliation. If there are more people involved and invested in bringing these matters forward collectively, it is more of a community response instead of a lone person in isolation stepping forward.
Federal employees are terrified to serve as witnesses. It's hard to prove these cases without contemporaneous witness testimony. They are paralyzed with fear about being retaliated
Commissioner Narasaki.
Thank you, Madam Chair. I wanted to follow up on one of the earlier questions I had, Mr. Brooks, that you had acknowledged that EEOC does not have an enforcement mechanism if it disagrees with how an agency's EEO program operates. So do you feel like EEOC would be stronger if it did have that kind of authority?
Yes.
Thank you. That gives me time for other questions. The second question I have is, oftentimes the goal for agencies is to show that they have zero complaints, right? So what do you do when you have an extremely large agency and they're reporting zero and you're thinking, how is that humanly possible? Is that a red flag for you? Is that something that you raise with them?
Yeah, so we would call that a trigger because, you know, when you have humans together, you're going to have conflict. So have zero and you have a significant workforce, that will be a problem. But we have other data to look at. We will look at if it's a homogeneous work environment, maybe that's why. You know, you have all folks that came from this university and have the same background, and that's not good because your recruitment efforts are not broad. So we would have instead of a complaint discussion, we have a discussion about inclusion. And so we also will have their results of their Federal Employment Viewpoint Survey by race, demographics, and disability status. So if there are no complaints, but your employees with disabilities say that they're lacking opportunities, failure, they're not getting promotion, they're not being awarded appropriately, then that's a different data point that would undermine the fact that they
State Department, NASA, and STEM organizations. In the order in which they speak, our panelists are Gregory Smith, Director of Office of Civil Rights and Chief Diversity Officer, U.S. Department of State; Jana Ben-Yehuda, President and CEO, Truman National Security Project; Stephen Shee, Associate Administrator, Diversity and Equal Opportunity at NASA; and Heather Metcalf, Chief Research Officer, Association for Women in Science. Mr. Smith, please begin.
Madam Chair and Commission members, good morning, and thank you for allowing me to appear today to share the Department of State efforts to combat sexual harassment. As you stated, you have already seen and have in your possession, have read our prepared statement. So I would just like to limit my comments to some things that I think that kind of stand out for the Department of State. Our mission of my office is to promote fairness, equity, and inclusion throughout the Department of State. And one of the most critical aspects of any workplace, if it's going to be successful, is to take care of its people and to create a culture of respect and dignity. And that is what we try to do. With respect to harassment, we pursue zero tolerance. And I say pursue purposefully because we have not completed or achieved zero tolerance, but that is what we are working towards. Three components are involved. Our policy, we think it's a clear policy that includes a process to fairly and objectively investigate harassment allegations. And I'm talking about our internal policy that is internal and unique to the Department of State. And we're not talking about one may pursue harassment claims under 1614 in terms of these remarks. So I want to be clear about that. Also awareness. There's proactive training and awareness of all employees with a view to prevention. And the training not only enumerates the employee rights, but also explains the responsibilities of leadership. And leadership participation support is key at all levels. And also consistent follow-up on both the policy and the awareness. And my office takes every allegation seriously, and we give everyone the benefit of the doubt. And in terms of our training, not only at headquarters, but also in the field, and I mean around the world in over 200 countries and in our embassies and consulates, that message is carried out. So our program, we believe is strong, and we were talking again the internal program, and the aim is to ensure that potential victims are relieved of the harassing behavior as immediately as possible, and that at the conclusion of a thorough investigation, the alleged harasser is properly disciplined if it is so warranted. I'd also add that our process, our program is collaborative because it goes across offices, not only in our office, the Office of Civil Rights, but also and a unit of our Human Resource Office, the Office of Conduct, Suitability, and Discipline, and our diplomatic security colleagues if warranted. One of the most critical aspects of our program, we believe, is the mandatory requirement of supervisors to report. And in terms of our internal allegations that come into our office, I would say a little bit less than half of those come in from supervisors adhering to this requirement. And it's plainly stated, supervisors and other responsible management officials are required to report directly to our office any behavior that they observe, reasonably suspect, or become aware that may be considered discriminatory or sexual harassment. Individuals are able to report 24 hours a day, 7 days a week, because we're around the world, something that's happening all the time. And so we want our colleagues to know that we are available. In terms of the process itself, our office is responsible for gathering the facts, and that's all that we do. We gather the facts, we put a report together, and then we share that report with our colleagues in Human Resources for them to determine if there has been a violation of our department policy against harassment. And also it is their responsibility to determine what, if any, administrative or disciplinary sanction is warranted. In terms of training, we train, I would say, from top to bottom. All new employees, from ambassadors to chief of missions, are trained by my office. Also, we train all new foreign service officers. Of course, we train new civil service officers. We do a specific intern training. So everyone is aware of what the requirements are per our anti-harassment program. Also, we do a lot of specific training for supervisors, because supervisors have certain responsibility that is key to what we're trying to accomplish in terms of the culture that we would like to create. Not only is my office trying to champion that, but also we've been privileged with secretaries of state that have championed that as well. Just last year, in 2018, the Secretary of State had a mini stand down to talk about harassment and what is expected in terms of the culture and how we want to treat each other. And on the spot, he designated or required us to do mandatory training for the department-wide, and that's 75,000 employees, which we did. I'm proud to say that we did. It was a heavy lift, but we did it. The genesis of our online training really came out of that requirement of our agency-wide training. And we learned a lot of things in the agency-wide training, and a lot of that training was face-to-face. Whether we assembled people in venues in the department or whether we were overseas. And so we learned a lot of things, and that became the genesis of our online training. Before I close, I'd like to say a couple of things. Number one, everything that we've done in the Office of Civil Rights has been supported by our leadership, both visibly and vocally, and I think that that is key in terms of the type of environment or work culture that you want to create. Also, I've heard in terms of who is covered with our in-house program, we cover anyone that works in our workplaces, and that would include contractors and thank you.
Ms. Benyahuda.
Good morning. It's an honor to testify before you today on the critical topic of sexual harassment and assault at the Department of State. I served at the department in a range of policy and intelligence roles throughout the course of my 12 years at the agency from 2001 to 2013. In 2014, I founded the Women's Foreign Policy Network with a mission to advance women's participation in foreign affairs. 5 years later, the network has grown to 3,500 women in over 100 countries, the majority of whom are current or former employees of the Department of State. As the news of Harvey Weinstein's staggering abuses gave way to the reckoning of the Me Too movement, it became clear to our community that there was finally space for the women of the national security world to be heard. So together with my friend, former Ambassador Nina Hashigian, we wrote an open letter, the same letter to which Congresswoman Spear referred, to the national security community titled #MeTooNatSec. This letter was signed by 223 women in the field, including 70 current and former U.S. ambassadors, and was published by Time Magazine in December of 2017. The full text of the letter and all of my further recommendations have been submitted for the record, and I'll read a selected portion of that here. We, the women of the national security community, come from all walks of life and all corners of this great nation. Those of us who have worked for the United States have sworn an oath to protect and defend the Constitution. We, too, are survivors of sexual assault, harassment, and abuse, or know others who are. This is not just a problem in Hollywood, Silicon Valley, newsrooms, or Congress. It is everywhere. These abuses are born of imbalances of power and environments that permit such practices while silencing and shaming their survivors. Indeed, in our field, women comprise a small fraction of senior leadership roles, just 30%. The pipeline is not the problem in much of the community. Talented women enter most of our agencies in equal numbers as their male counterparts, yet this is less true of the armed services. At the State Department, female Foreign Service officers enter at equal rates to their male colleagues, and yet with each subsequent promotion, the number of Foreign Service women decline, especially at senior levels. Women now comprise 15% of all active duty military, an historic high, but women who are already serving in senior ranks are being promoted far less frequently than their peers, and the same is true at the State Department. Many women are held back or driven from this field by men who use their power to assault at one end of the spectrum and perpetuate, sometimes unconsciously, environments that silence, demean, belittle, or neglect women at the other. Assault is the progression of the same behaviors that permit us to be denigrated, interrupted, shut out, and shut up. These behaviors incubate a permissive environment where assault and harassment take hold, and it's time to make it stop. The institutions to which we belong or have served all have sexual harassment policies in place, yet these policies are weak. They are under-enforced, and they can favor perpetrators. The existence of policies, even good ones, is not enough. We are proud to have served our nation and to have safeguarded its ideals, and we are proud to have worked alongside the talented men and women who make up our workforce. Imagine what more we could achieve together if we took steps to ensure that women could work free from fear and conflict, and confident that their gender would not affect their opportunities. Because Time Magazine published this letter on December 1st, it means we were collecting signatures over the Thanksgiving holiday, which I can assure you is not prime signature gathering time. I wish I could tell you it was a challenge, though, to find hundreds of women to make themselves vulnerable and put their names to this letter, but women came forward in droves. We held the letter open for just 1 week, and after the letter closed, 3 times as many women asked to sign. Since the publication of this letter, the Department of State has begun to undertake some efforts to address organizational deficiencies surrounding harassment and assault, though transparency surrounding these steps has been limited and making assessing such efforts a major challenge. In an effort to ensure that such responses continue, deepen, and remain a viable and visible priority driven by accountability and transparency, additional oversight is required. Reducing the incidence of sexual harassment and assault requires really 3 elements: transparency, accountability, and more women in leadership positions. On transparency, the desired outcome is that all employees, regardless of seniority, know department and agency policies and processes regarding the reporting and adjudication of assault and harassment. Such processes and procedures must be clearly and consistently communicated to all employees on a recurring basis, and aggregate data on complaints and outcomes is publicly available and current. We are falling far short in the current environment. On accountability, the desired outcome must be that complaints of sexual harassment and abuse are adjudicated in a timely, consistent fashion, and that guilty parties are disciplined swiftly, not promoted, and dealt with appropriately. Levels of harassment and abuse should decline dramatically, and underreporting of incidents should be reduced significantly because victims have confidence in the process and do not fear retaliation. On gender parity in leadership, this community must also address the serious gender imbalances in senior leadership positions because male-dominated teams have been found to be more prone to abuses, and more diverse teams are consistently linked to better outcomes. And we want to see leaders and managers across the community held accountable. Gender parity reduces the imbalance of power that is widely regarded as the sine qua non of organizations where assault and harassment take hold. These are important steps, but parity is key. The best part of all of this is that we know what works. We know it. And identifying solutions, it's not the problem. We have those solutions at hand. The challenge is to implement, but implement we must. Women at the Department of State, one of the most competitive employers in our country, enter in equal numbers to their male counterparts and have for years. And yet, fewer than 30% of senior positions are held by women. Women do not become less competent over time. They are often treading water in an organization that systematically excludes them. They are harassed and assaulted regularly, passed over for awards, promoted less frequently, and when they become mothers, they have no paid leave and have to fight for on-site childcare. Sexual assault is a crime, pure and simple, and when the department puts the onus on women to prove themselves while making too few resources available, and when the number of reported cases doubles from the year prior as occurred in 2018 and no additional case managers are added, and when the backlog stretches 18 months old, women are not being served. Thank you.
Thank you very much, Mr. Sheep.
Honorable Chair and other commissioners of the U.S. Commission on Civil Rights, thank you so much for inviting me to speak today about sexual harassment in federal government workspaces.
If you pull your microphone a little closer to you, the court reporter will be able to hear better. Thank you.
Is this better? Honorable Chair and Commissioners of the U.S. Commission on Civil Rights, thank you so much for inviting me to speak to you today about sexual harassment in federal government workplaces. I very much appreciate your interest and leadership in ensuring we're jointly doing everything possible to prevent harassment in federal workplaces and promptly correct harassment when it occurs. At NASA, we place the highest importance on excellent leadership and employee engagement for mission accomplishment. And we embrace the saying, if we take care of our workforce, they'll take care of the mission. In the past several years, the issue of sexual harassment in the workplace has received significant attention and heightened awareness in the United States. Because of this national attention and the work of academic institutions and other leading organizations, such as the U.S. Equal Employment Opportunity Commission, we have a far greater understanding of the persistence and pervasiveness of harassment throughout our country, across multiple sectors, including in places of employment. We know from research that harassment frequently goes unreported. We know harassment causes significant mental, physical, and economic harm to victims, and we know harassment in the workplace harms employees and their organizations with many significant detrimental work impacts, including decreased attendance, decreased productivity, decreased morale, increased turnover, and reputational harm. We've also learned a great deal about contributing conditions and risk factors for harassment. At NASA, we place the highest priority on equal employment opportunity, EEO, and diversity and inclusion, and on taking care of our workforce and empowering them to contribute fully to our mission. Our emphasis on our people is reflected by our high employee engagement scores in the U.S. Office of Personnel Management's annual Federal Employee Viewpoint Survey, where we've been ranked by the Partnership for Public Service as the best place to work among large federal agencies for 7 consecutive years. NASA also ranked #1 among large federal agencies in OPM's new inclusion quotient, the new IQ, in each of the previous 5 consecutive years since OPM began using the new IQ. This is an index comprised of 20 FEVS questions that assess the inclusiveness of an agency's work environment. Because of our emphasis on our workforce, NASA initiated a first ever agency-wide anti-harassment campaign on February 1st, 2018. Our campaign is based upon established statutes, case law, and other applicable legal authorities and guidance pertaining to workplace harassment. It has been heavily shaped by the EEOC's June 2016 report of the co-chairs of the Select Task Force on the Study of Harassment on the Workplace, and by the EEOC's Model Equal Employment Opportunity Program, Management Directive 715. The goals of NASA's anti-harassment are twofold. First, to enhance the safety and effectiveness of NASA's workforce, and then secondly, to enhance the safety and effectiveness of NASA's mission. The campaign consists of 2 strategies. First, proactive prevention of harassment at NASA, and then secondly, prompt correction of harassment at NASA when it occurs. I'll briefly describe each of these strategic approaches. The first strategy of the campaign, proactive prevention, includes the following components I'll briefly summarize. First, On February 1st, 2018, the NASA administrator issued a video message and a written memorandum to all NASA personnel communicating his expectations for the appropriate culture and values in the NASA workplace, emphasis on accountability and reinforcement of the agency's anti-harassment policy and requirements for all NASA personnel to exercise reasonable care to prevent and enable the prompt correction of workplace harassment. This video message actually is public. It has been posted on YouTube. It's available to the entire world. Following the administrator's messages, NASA took additional steps to ensure a demonstrated commitment from agency leadership. As the executive responsible for leading diversity and equal opportunity at NASA, I personally conducted briefings for all NASA senior leaders on NASA's anti-harassment campaign and our programs. The purpose of these briefings was to raise awareness and leadership support for agency-wide implementation of the campaign and to enlist NASA leaders to champion anti-harassment in their organizations. Initially, I briefed the heads of each major NASA directorate and center in the field at the administrator's senior staff meeting in February 2018, and I followed this with briefings in 2018 for all other senior executives and managers across the agency's 8 of 10 NASA field centers. I plan to complete these briefings this year. During 2018, I also personally delivered multiple anti-harassment trainings at 8 of the 10 NASA centers that I visited. These trainings used engaging interactive scenario-based dialogues to enhance knowledge for participants on how they may jointly take ownership for the prevention, identification, intervention, and prompt response and correction of harassment. The trainings also focus on helping participants understand the critical link between anti-harassment and the agency's mission, so NASA personnel understand the value proposition of anti-harassment and will fully commit and contribute to helping NASA prevent and promptly correct workplace harassment. These training sessions received extremely high participation evaluations and specific feedback on the high quality and the practical applicability of the trainings. Additionally, we're finalizing a new modern online training solution using gamification and simulations to deliver training on anti-harassment across the entire federal agency. In 2009, we established an agency-wide anti-harassment program to help assure safety in workplace and mission success. Our program involves a highly collaborative and well-coordinated community of practice, including EEO offices, anti-harassment coordinators, Office of General Counsel, Office of the Chief Counsel, NASA's Office of the Chief Human Capital Officer, and senior NASA leaders. The community of practice brings together all relevant organizations to ensure a joint and collective thorough response for early intervention and prompt correction. To ensure continued excellence in the operation of this program, I convened an anti-harassment in 2018 at the Johnson Space Center to train and coordinate the community of practice. I'll briefly mention Strategy 2, Prompt Correction, which is timely, effective execution of our anti-harassment policy, procedures, and program. We've benchmarked our anti-harassment policy and procedures with the EEOC. They've validated our policies and procedures, and they've held our program up as a model program. I have a great amount of data indicating the success of both our policies and program and our campaign that's contained in my written testimony, so I won't go into that in detail. We continue to centrally coordinate NASA's anti-harassment coordinators across the country. We evaluate the program. As I indicated, we have data indicating initially some very positive preliminary campaign outcomes. And then we also have a role publicly as a federal science agency awarding grant funding to STEM institutions that do research and development, and we're able to promote anti-discrimination and anti-harassment across the public. In conclusion, I'll just reiterate that at
Thank
NASA,
you, Mr. Sheik. Thank you.
Thank you.
Ms. Neka?
Thank you for having me here to present testimony today. I come to you today as Chief Research Officer for the Association for Women in Science, a nonprofit based here in DC that supports equitable and inclusive STEM workplaces through research, policy, and practice. I also speak from personal experience as an interdisciplinary scientist who's been the direct target of a variety of forms of harassment throughout her career. I'll start with a couple of definitions here and then share some of my experiences with you. So first, while we often focus solely on what is commonly understood to be sexual harassment, that is unwanted sexual attention, sexual assault, or sexual coercion, behavior that is sexual in nature comprises only a small portion of harassing behaviors. Gender harassment is the most common form of sexual harassment and consists of verbal and nonverbal behaviors that convey hostility, objectification, exclusion, or second-class status based on a person's gender. This is so widespread that it goes unnoticed. and often isn't recognized as a form of discrimination or harassment when people experience it. Harassment also is not just based on gender or sex, and for workers who are part of more than one marginalized social group, it often has a multiplicative effect. You'll hear these reflected in my experiences and in the data that I'll share today. As a first-generation low-income college student, in some ways I was fortunate I didn't first experience much harassment and exclusionary behavior in my field until I entered graduate school in computer science in 2003. Walking the halls of my department, 6% of which was comprised of women, students and faculty assumed I was an administrative assistant and regularly asked me where the kitchen was. My classmates and professors gave me quizzical looks in class and asked if I was in the right room. Students told me I was only admitted to the program because of affirmative action, assuming I couldn't qualify for admission on my own merit, and not knowing I had graduated top of my undergraduate class in both math and computer science, while working 2 jobs to pay for college. Teaching assistants offered gendered responses to mistakes I made in assignments. Men who made the same mistakes didn't receive this commentary and were often not docked the points that I was. I witnessed racialized comments targeted at students of color and international students. I overheard homophobic remarks about LGBTQ+ students. I noticed students with visible disabilities were avoided and mocked. I observed how uncomfortable these interactions made not only the targets but bystanders, regardless of social group. I shared office space with an undergraduate who insisted on revealing graphic details about his sex life, despite my repeated protests. As he began to encroach on my physical space, I felt increasingly unsafe and turned to the department for help. Rather than addressing his behavior, they moved me. I attended conferences for women in computing. At one session, a student asked how to handle situations where a respected member of the field engaged in inappropriate behavior. The panel advised wearing wedding bands to discourage the behavior, to pretend to be something that we weren't, and hope that those who crossed established professional boundaries would somehow respect feigned personal ones. These experiences are just a small snapshot from my own career. Through 15 years of research, I've also gathered thousands of stories from STEM professionals around the country and across sectors about the bias, barriers, harassment, and other forms of discrimination they've faced. Every STEM professional in the federal government I've included in my work has had at least one story of sexual harassment experience or other identity-based harassment experience. There's a whole sub-movement, Me Too STEM, because of how common harassment is in these fields, even in the government. The recent National Academies report that was just released found that 58% of women among faculty and staff in universities experience sexual harassment. This is also the same pattern in federal workplaces, as you can see on the slide that I have up on the screen, where between 21 and 69% of women experience gender and sexual harassment. On the next slide, you'll see that in a survey of astronomers and planetary sciences, women of color experience the highest rates of race and gender-based harassment and assault in their STEM workplaces at 28% and 40% respectively. In the next slide, the American Physical Society found that LGB women, gender nonconforming, and transgender physicists experienced harassment and exclusionary behavior at 3, 4, and 5 times the rate of LGB men, respectively. On slide 5, our AWIS survey research found that 37% of white women with disabilities experienced disability-related stigma, discrimination, and harassment at work. For women of color with disabilities, this was 73%. For LGBTQ women of color with disabilities, it was 100%. Employees who experience or witness harassment face negative health consequences, lowered job satisfaction, lowered field satisfaction, avoidance behaviors, and if they report, they often encounter retaliation and incur financial expenses, as we've heard throughout the discussion today. Organizations suffer too, encountering reduced productivity, increased use of sick and annual leave, unnecessarily lose talented employees and public trust when the culture of harassment goes unaddressed. These costs are even greater in environments like STEM, where harassment is normalized and downplayed, threats of retaliation are at an all-time high, and a lack of trust in the reporting and investigative process produces barriers to reporting and support. While the Commission's work to review policies and programs to address, report, and resolve federal sexual harassment claims is important, equally important are educational and cultural efforts to prevent all forms of harassment, bias, and discrimination. To do this, federal workplaces should address the perceived tolerance and acceptability of harassment by making it clear that harassment of any kind is unacceptable. Federal workplaces should move beyond minimum legal compliance to change the existing culture to one that is inclusive and respectful. They should also improve transparency, efficacy, and accountability in the reporting process and written policies, as well as everyday decision-making. They should also gather data to inform policies, procedures, and cultural changes. Thank you.
Thank you, Ms. Metcalf. Now open for questions from my fellow panelists and fellow commissioners. Commissioner Dagwood.
Thank you for your testimony. On the previous testimony, which some of you may have heard on the previous panel, there was testimony about the notion that requiring federal employees to report first through their agency before things can move to the EEOC creates a problem. I'm interested in your perspectives on this and whether having an option of going straight to the EEOC would afford greater remedial power.
And anyone who would like to answer should go right ahead.
Yes, I heard the prior panel, and I can see both sides of it. But the one thing that I would argue in favor of the current system is number one, all agencies are different. Even though EEOC has a kind of a, and I don't mean this to be pejorative, a one size fits all for all agencies in terms of process, but each agency is different. And the one thing I would say in particular for agencies like my own is that there's a unique work environment, workspace, and a mission. And so I think that we have found that an example for EEO cases that go to ADR, if we bring in outside mediators, we spend an inordinate amount of time in terms of trying to bring them up to speed in terms of what the work center is like, what the work environment overseas is like. So I would say that there is some benefit to keeping the process in-house initially. I do agree with the prior panels in terms of more oversight to ensure that the programs are doing what they're supposed to be doing.
Sorry. As I mentioned in my testimony, we've learned a number of things very emphatically from the Me Too movement and recent research. That includes the importance of early intervention, and also, as my fellow panelists here testified to, creating an atmosphere of psychological and physical safety where individuals can come forward and actually report incidents. The Me Too movement informed us that there was a spate of reports in recent times that involved actions that occurred decades ago. That's unacceptable. That doesn't enable us to be able to provide early intervention. And so at NASA, we believe the more multiple avenues and the more avenues that provide psychological and physical safety for victims to come forward and report and get early intervention are absolutely appropriate. I won't necessarily opine in terms of whether there should be a process that circumvents the EEOC, but at NASA, our anti-harassment program encourages people to come forward immediately. And we are processing reports of harassment on average in 51 calendar days. And that includes all of the fact gathering, the fact finding, and collective coordination within the agency to determine response. We've had a significant percentages of those reports resolved. They never even needed to go forward. And a very, very high percentage of those reports have been resolved despite our finding that there was no violation of our anti-harassment policy. We're trying to be forward-leaning, and so if there are aspects that are not supportive of a productive workplace, we're going to fix it, even if it doesn't rise to the level of a legal violation.
I would just add that women deserve the choice in this regard. I think there are several circumstances in which the folks who would be adjudicating complaints could be abusers. Or also in a chain of command, or also affecting promotion, since it is handled within human resources. So there are opportunities. I think if there are ways for women to seek due process through other means, if EEOC is one of those, I think that should be considered. The bigger issue to my mind is that very few people at the Department of State seem to have an understanding about where to go first, because there are several different adjudicating bodies depending on whether you're overseas or you're in the United States when the issue takes hold. So I think it's a potential area to address grievances from folks who are facing that within their chain of command, which is a very common problem to have the option. But it's obviously just one element.
I'd also add that part of when we're talking about the value of transparency in this, part of that is also making it really clear the different options that a person who's experienced behaviors like this has. So whether it is filing a formal complaint and what are the
Sadly for the moment. I think it's back.
That's you. Oh, there we go. So whether there are formal pathways to filing a complaint and what that might look like, and what the potential costs of that, whether it's financial, the length of time that they need to prepare themselves for, if there's a review or an investigation that needs to happen, if there are other pathways that are possible. As we heard on the first panel, there are varying degrees of severity in the behavior where you may just need to have an educational moment with someone who says something that's inappropriate and didn't really recognize the level of inappropriateness that was there, versus someone who has been assaulting employees for decades, for example. Very different levels of severity that you need to think about what's the best course of action there. So making sure that you're creating transparency so people can see the pathway forward and so that they can make decisions on what they're willing to take on and what they're not.
Thank you, Ms. Ben-Yehuda. I think that there was a State Department report about, an OIG report about the State Department's disjointed reporting mechanisms. In your view, that this was in 2014, in your view, has that been remedied and clarified?
No. Folks don't know where to go. And you hear different things depending on where you are. You hear different things depending on how experienced your manager is, especially for folks overseas in conflict zones in Afghanistan and Iraq who might be on the ground reporting to somebody from a different agency. There is a real lack of clarity. And so, I think maybe this is something Mr. Smith could address when somebody goes to OCR, when somebody goes to DS, when somebody goes to human resources, because all are adjudicating at various stages. And I think folks have a real lack of clarity about where they should go first.
Mr. Smith, 2014 reports out there says it's disjointed. Where are we today? What improvements have there been? What needs to happen?
Well, currently, in terms of any employee that feels that they have been harassed sexually or discriminatory harassment, the one stop in terms of reporting is to our office. To the extent, and we liaise with diplomatic security only when the facts demonstrate that there may be a sexual assault. My office does, as I said earlier, the fact gathering in terms of what happened to determine what the facts are. Once we compile a report, we share that with human resources for them to determine whether there's merit to the allegation and to determine whether there's any administrative or disciplinary sanction is warranted. With respect to awareness, we do an extensive training program when individuals are assessed onto the department. In terms of overseas, we respond to specific requests for post-training. And when we go to post, we will only go if everyone from the ambassador on down agrees to sit in the training. That does not always happen, but we try to make that mandatory, and we delineate the training not only for U.S. direct hire managers and employees locally employed staff, managers, and employees, because employees' rights, but managers have responsibilities in terms of the environment that we want to create. And for those posts like Afghanistan, Iraq, Pakistan, we have them on a rotation in terms of about an 18-month rotation to go back out to do the training and awareness. So we are, I think that we are doing a pretty good job. We can always do better. It does distress me to hear that people are out at post and they do not know where to go. Since 2013, our office with our HR office have sent a cable out to kind of delineate not only what is required, but where to go. And we have sent that out in subsequent years. So clearly, there's more work for my office to do. If that is the case, if that is what you are hearing.
I would just add very briefly that, for example, if Mr. Smith says that folks are being sent out every 18 months to high threat posts like Afghanistan and Iraq, the average tour length there is 12 months. So it's conceivable that there could be a range of people there who never experience training on the ground.
Also, Mr. Smith, the criticism in the OIG report, was that fair or not fair?
You know,
Qualified yes?
Yeah, a qualified yes. We'll say a qualified yes. But with respect to anyone that's going out to the high threat post, our office, in association with our training organization, the Foreign Service Institute, we have a training called FACT training for those individuals that are going to the high threat post before they go. So we try our best to cover individuals where we can. Obviously, if individuals are saying that they are not getting the training, we will have to go back and relook at how we're doing things.
And apart from those cables that you mentioned, were there any specific efforts taken to address the criticism of a disjointed reporting process in the OIG report?
We have continued to let individuals know, not only through those cables, but also through our all training, that our office is the office to submit all allegations of harassment, be they sexual harassment and or discriminatory harassment. And we do that for training of deputy chief submissions going out. We do that for ambassadors going out. We do that for HRO officers, human resource officers going out to post. So again, we try to cover the gamut of those folks that would be in charge, try to cover the gamut of those folks that are advisors to supervisors that are at post. But to the extent that we're falling short, we will redouble our efforts.
Madam Chair, I yield to other members. I'll get back in the queue after other commissioners have had an opportunity.
Thank you. I just want to follow up on those answers, Mr. Smith. Am I correct that the HR department does not report through you within state?
No, HR does not. I'm sorry. HR does not report to me.
So you're not really the one-stop shop for resolution, then. You're the one-stop shop for reporting. But as you testified, that the HR department is who decides sanctions.
Yes, I said that we are collaborative, and that the program goes across offices. We take the reporting, we do the investigation or the inquiry, we put the report together, and then we liaise with the Human Resources, Conduct, Suitability, and Discipline Office, and they make the determination in terms of, has there, one, been a violation, two, if so, should discipline or some type of administrative sanction be warranted. We think that is good because we are neutral. We just want to get the facts. What were the facts on the ground? And then we share that with, as I said, the HR for an assessment independent of us, whether or not there was a violation of our policy.
So I want to push on that a little bit. I think it's helpful for you to be neutral, and certainly that's what we heard in the last panel that EEOC advocates for as well. But EEOC also adjudicates on the end. I mean, so it's helpful to be neutral in determining what the facts are. But if you determine that there is a violation of the policy or violation of core anti-discrimination rights, if the HR department does not resolve in a way that you would have recommended, there is no resolution for your office. Is that right?
Currently, yes. Technically, yes, that is correct.
Commissioner Clendy?
Thank you, Madam Chair.
Ma'am,
Yes,
and
please.
I'm talking about our internal policy.
Is that distinct from an external policy that actually has a mechanism?
Well, it is. There's a 1614 process that
Right.
I think a lot of the last panel was addressing, and I'm talking about the process that our office manages under our Foreign Affairs Manual. So
That is certainly well outside my experience of agencies. The agency that I'm most familiar with, the Department of Education, when I worked there, the EEO office was the neutral arbiter of what the facts were and also the determiner for what the ultimate penalty would be. There was not someone else who did that. And I think that provided quite a bit of confidence to department staff about whether what the policy was also the policy that they would expect to be living.
Thank you, Madam Chair. Just want to give an example. The other day I was at a hearing and we had done a briefing on police use of force. And one of the aspects of police use of force is de-escalation. And this fellow from the police department was testifying about how great their training was. You talk about your training. He said, yeah, we include 15 to 30 minutes of it at the Post Academy. So my question comes down to, what does your training consist of? How long is it? Who develops it? And how often is it given? And that is to employees, managers, and bosses. If anybody wants to, you could start there and work down if you like.
First of all, some of the training that we do is in conjunction with our Foreign Service Institute, and we have modules in all of the leadership training. We have modules in, as I said, the sessions training for new civil service employees, for interns, for new foreign service officers, for our DCM training, also for our ambassador training, and for human resource officers that are going out to post. That is determined on the rotation, not rotation, but when those individuals are brought into the department and they're going through their orientation, we are invited out. And typically we would have, I would say, generally anywhere from 45 minutes to 1 hour. And some of those training courses, they are longer depending on the responsibilities of those individuals when they get to post. Also, we do training upon request, not only here domestically, but also for post embassies and consulates when they request training. Those trainings that are upon request, for example, for an embassy, may be anywhere from 2 to 5 days, and we're trying to train the whole post, not only our direct hire American employees, but also the locally employed staff.
Do you have a schedule of training, like regular schedule? I have to train this embassy once every other year or once a year, or does every employee have to go through this training once a year if it's an hour? Is there any schedule like that, or is it like when employees come in, they get the training, when they get promoted, they get the training? That's what I think you said. When they get promoted, they get the training. When they hit upper management, they get the training. And it's once, or do the employees receive it on a regular basis? I think that's part of my question. I mean, it's not real complex. I understand training modules. I understand different levels of training. You said an hour, then you said 3 to 5 days. That's because you have so many people to go through. I mean, let's get straight about the program itself, just so that I get a clear picture.
The first comments that we're making about training had to do with training that we do in conjunction with our Foreign Service Institute. They are responsible for all training for the Department of State employees. For certain individuals that are coming in, be they Foreign Service, Civil Service, specialists, we are invited to provide a module of training for those issues that are unique to the Office of Civil Rights, whether it's EEO and or harassment. That schedule is dictated by when those new employees are brought on. So we do not control that. The second training scenario that I was talking about has to do when training is requested by our office, and it may be domestic or it may be overseas.
As if I'm an embassy, I'm an ambassador, and I say, hey, can you come out and train me?
Correct.
Okay, so that's ad hoc.
That is correct.
Okay. Is there a regular scheduled training on a basis to renew the training with every employee in your agency?
With respect to the high threat post, yes, I mentioned earlier our 18-month rotating training. Other than that, no, there is not a schedule of training.
So people can go years and not get the training renewed, a renewed kind of refresher course, so to say. Yes, sir.
No, I don't think that is fair.
Thank you.
If I could just add, the Department of State is somewhat unique in that most of its workforce is overseas. And so when you hear the gentleman talk about folks, being ad hoc and receiving training maybe every 18 months or so, it's worth keeping in mind that the vast majority of folks overseas are locally employed staff, which is to say they're not American citizens. They are citizens of the host country. These are the most vulnerable people at a given post. These are very precious held jobs that are passed from generation to generation. It's not uncommon to meet somebody, a motor pool driver, whose grandfather also drove for the embassy. People have a lot of pride in working for our government overseas. And so that means also that they're at least in the position to be able to come forward. They're not regularly trained. Contractors likewise are not being trained at FSI. It's not required. And the requirements for contract companies themselves depend on the threshold, the number of employees.
And you think training should be what? Should it be improved? Should it be regular? Should
Improved, regular,
trained?
right. So the Department of State has a training continuum. If you come in Foreign Service or Civil Service, you have a certain number of wickets that you're moving throughout your career. Sexual harassment and assault training and prevention efforts should be integrated as a part of that regular training continuum.
But it's not.
It's not.
Now my favorite agency in government, NASA.
Thank you, Mr. Commissioner. We are the best place to work in the
Other than the U.S. Commission on Civil Rights, of course, but
except for all, of course, except for the current institution. Yes, sir. So I'll answer your question very briefly, but also touch upon another really important point central to your question. So first of all, we have a regular schedule of the Institute our mandatory No Fear Act training every 2 years. We're implementing a new schedule for mandatory EEO training single year for managers and supervisors. As I indicated in my oral testimony, we're also developing a course for anti-harassment that will be in more places, that will be online. It's about a 60-minute course. It's very interactive. It's focused on simulations and gamification.
Is it important that the training be developed by the agency? It sounds like you're developing the training.
Yes, sir.
Who develops your modules?
We develop our modules.
Does it work that way? Because do you do it in conjunction with the EOC, or where do you get your expertise except from in-house? Do you get anything from out-of-house, outside?
Sometimes we do, and sometimes our training is based on the issues that come into our office. So those issues that we feel that need to be highlighted, we can direct our training to address that.
So in the government, there's no baseline subjects that are supposed to be trained on. Is that correct?
So actually, sir, EEOC has issued guidance on the effectiveness of anti-harassment procedures and policies, and so we follow those guidelines. We have decided to develop this training in-house because I'm actually a product of EEOC, having worked there for 12 years, and I've worked on anti-harassment for the majority of my career, and so I feel that I'm very expert in this area.
I think what the question is really asking is there consistency in training across the board? I mean, agency to agency, plus special situations that your agencies, like you have employees around the world, you have employees around the world. Online is a great thing. But is there any consistency in the training?
So, sir, I think that's an excellent question. I think the consistency does vary from agency to agency. So there's a value for consistency and standard of quality, and also to your point, there's an important need for customization for the specific needs of the agency. And I think EEOC and other organizations has provided really good leadership here, and also regularly evaluates agencies' EEO programs as well. If I could just add very briefly. Thank you, sir. I appreciate your question about the quality of the training and focus on educating the workforce, including leaders. I would also add to that, what's really important is not just education. We actually target our training on a different learning outcome. And that learning objective is basically to take the onus away from the victims to have to figure out what to do if they're a victim of harassment. They shouldn't know, but they shouldn't have to know and navigate a specific path in order to get relief. So we put the onus on our supervisors, our managers and executives, and we put the onus on the rest of the workforce to be able to act as bystanders, to intervene, and to share a collective it's on us responsibility. And then ultimately, sir, our real focus of this training is not just information and knowledge, it's actually to emphasize the critical importance of this area because it impacts our missions. And when people understand it impacts our missions, and this is ultimately a broader inclusion issue, and then when they actually start seeing their fellow coworkers not as targets or potential opportunities, then they see them as teammates and human beings, and that prevents them from harassing others.
Thank you. Commissioner, I need to,
Absolutely, it's critical.
we need to move on. Thank you. Good. Commissioner Narasaki?
Thank you, Madam Chair. So we're going to continue on the road to training. So does either state or NASA conduct bystander intervention training for employees on how to take action when they witness something that they think is inappropriate?
Commissioner, thank you so much for that question. In the online training that we're developing, that is a key part of that. So in fact, these are akin to virtual reality scenarios, and the user of the training, it's not important whether they're a supervisor or a regular employee. The idea is they witness something, they have the opportunity to then make a series of decisions in terms of what actions to take, and it's all to encourage people to come forward and to be able to report it to somebody who can do something about it.
And do you actually have bystanders reporting at this point?
We actually do. We actually do, yes.
That's great. Is that something you try to measure progress on?
We're keeping those statistics. Part of this is that we don't want to report this widely to the workforce in terms of who's reporting it, because we want to provide the psychological safety for everyone in the workforce to be able to come and report it. But we're seeing gains there. Again, the approach we're really targeting is to make this an issue for the entire workforce. It's not an issue for victims of harassment. It's not just an issue for leaders.
Great. And state?
Yes, we're beginning to train on that. Yes.
Great. So the state, this was giving me flashbacks to when I was, the summer before I was a senior at Yale, I was at a special international program, and I was an international studies major basically, and I was working on my application for the government because I wanted to work for the State Department. We came into contact with State Department officials. And so I was very excited and wanted to ask about the career. And I was told, honey, you're a woman and you're Asian and you have no opportunity for ever making it through the ranks at the state. And I went home and I tore up my application. So it really hurts me that it's still an issue 40 years later. We really shouldn't be at this point. So I just wanted to express that because I think for women, and particularly women of color, we should have those opportunities. And it's shocking to me because, you know, I was at Yale. So to be told that I would never be able to advance despite whatever qualifications I had was just really quite shocking to me. So, sorry, I just had to say that. I want to ask about the topic of maybe having special advocates at the agencies who could help take care of the power imbalance in terms of people who are victims. What do you guys think about that concept? Is that a good idea? Would that be helpful? What are the ramifications?
Thank you, Commissioner, for sharing that. And I too am really sorry that I feel like not a lot has changed. You know, one of the most challenging experiences for folks is the isolation and the loneliness that they experience as victims of harassment and assault. This is compounded by not knowing where to turn, by having to do a lot of digging, and over on an issue where it's not exactly like you would want to ask somebody, hey, by the way, George, where do I go for this kind of information? It requires a lot of work. It's lonely. You don't know where your case is in the process, whether it's still with OCR, if it's at DS, and maybe it's back in HR. Nobody, you have to trust that the department is being truthful, frankly, and telling you where you are in the process, but it's like you don't know what's coming next. You don't know what to anticipate. There is no support for victims, period, currently available. You add to that having people overseas reporting, very limited reporting chains to people who could be the abuser in question. And it's a recipe for under-reporting and frankly for women leaving the department. You know, if women are coming in 50-50 to their male counterparts and 30% of women are senior leadership, where are these 20% of women going? You know, we're not asking the questions. There are no exit interviews. I tried. I was there for 13 years. You know, nobody asked. I looked around. Anybody want to talk to me about why I'm leaving? There was no process. So having that kind of structural support in place, I think would be incredibly helpful, because so many women just leave or they decide they don't want to report because it's not worth it, because they see the high levels of impunity and they decide, I don't have the money, I don't have the time, and I'm not going to become a poster child for an issue that's going to ruin my career. So support is needed, and I think that's an excellent start.
I would agree with that. And also thank you for sharing your own experience with this. In talking with people across all of the sectors and in the STEM disciplines, there's this like desire to believe that there's a justice in this situation, and a lot of times the decision ends up coming down to what resources do I have available to me, whether that's emotional resources, because this takes a toll, health resources, financial resources, other kinds of support that are there. So having an advocate who is genuinely on the side of a person who's experiencing this is really important. A lot of people also expect that HR would have that role, and then find that HR is there to protect the institution. So that's one more situation that they find themselves in, where they're disappointed and this is not really the way things work. Justice isn't really a thing that exists in this process. It comes down to who can hire the best attorney, and then I have to decide whether I'm going to walk away, right? And so any resources that you can give to support someone who's going through that situation would be helpful in lightening that load for them.
And Mr. Shi, from a government perspective?
Thank you, Commissioner, for the question. At NASA, I am that power advocate. I lead and I centralize all the policies and programs on anti-harassment. I have a center seat at the leadership table, and I report directly to the administrator. But again, what I would say is that this is a collective responsibility. We know from the research that there are risk conditions, including power imbalances, that contribute to these types of factors. The lack of a homogeneous workforce, the lack of diversity at leadership positions. So those are environmental factors that are important to be cognizant of and to improve. Ultimately, again, I know I keep repeating this. Our success has been really reinforcing and just putting steel behind the value proposition that anti-harassment is directly linked to mission. And so we've really addressed that power imbalance because the very senior leaders, the administrator on down, through our workforce, they understand that with our really tremendously challenging missions, we don't have the luxury of excluding a subset of our workforce, and certainly not a subset of our future workforce, given the fact that we're seeing these retirements already. Institutional knowledge, we've got one of the oldest workforces in the country. We're seeing explosion of technology positions, and with the succeeding smaller generations, we're going to be in a huge talent war to compete for talent against other agencies, other sectors, and other countries. So the people and the leaders at NASA understand we can't afford anything that jeopardizes our ability to achieve the mission from an inclusiveness perspective and to be able to continue recruiting the future workforce. It's really that simple. And because of that value proposition, and because of tragedies in our past where people in their cognitive diversity weren't included, there were mission mishaps. And so people really understand that this is a mission distractor, it's a mission failure risk, and we can't afford it.
So, Madam Chair, I have other questions, but I want to refer to some other commissioners.
Do you want to do just one more?
Well, I did want to ask, one of the powerful issues that came up at state was the issue of the corridor reputation. And I think that's probably true in STEM as well, right? Where you have a small number of people who actually know what your expertise is. And everything in Washington is about who you know and who's going to stand up for you. So how do we address that issue in terms of that being a block for people wanting who should be reporting but are afraid to report?
I think that's a really important point that you've made, Commissioner. That was one of the first terms that I learned when I entered into the department, the corridor reputation. Because it matters a lot more than anything on your CV or anything else. And what that also becomes shorthand for is hearsay. And in a workforce where, foreign service officers are changing positions and vying for new positions every 1 to 3 years, there's so much turnover. The corridor reputation becomes a major factor for selection and for promotion. So one way to address that would be to look at the assignments process and to identify additional ways to reduce bias and make that process blind, especially for senior issues. As an intelligence briefer, I was the fly on the wall to many senior level conversations about, oh, she's really difficult to deal with. You don't want to deal with her. She complains, she this, she that. And that stuff really sticks. But if there is a process to handle those issues in a blind way, to introduce ways to remove unconscious bias, I think that would go a long way. Unfortunately, that's not what we have now.
I would like.
Oh, go ahead.
I'm sorry.
I would just add that that reputational piece is part of the reason why cases go decades without someone coming forward, is because people are waiting until they get to a position in their career where they have enough seniority to protect them from the potential ramifications of reputational harm.
I'd like to add two things. In terms of individuals coming forward, we do everything that we can to protect the fact that they came forward where we can. And we strongly enforce retaliation for taking any type of action. Also, our office has worked with HR and also the Foreign Service Institute to develop a course on mitigating unconscious bias, and also to the extent of unconscious bias in the bidding process. Our office worked with the Ombudsman and also one of our bureaus to do some training in that. And we're also trying to spearhead an effort to do a demonstration, if you will, in terms of a bidding that would tend to lessen the opportunity for conscious bias to impact on bidding.
Do you fire people who retaliate? How do you fiercely enforce against retaliation?
To my knowledge, no one has been fired, but that is not under the purview of my office. It would be under the purview of the Human Resource Office.
Commissioner, I think we tend to focus too much on process. It's important. It impacts the way we actually do our business, and it's easier. But I think the solution ultimately to a lot of this is really culture. And if we set the right culture from the top of the agency on down, and it becomes institutionalized, then we actually prevent a lot of these problems. I'll give a quick example.
I appreciate that, but I think that if you have people who retaliate and you don't fire them, then I think there's a pretty strong message that it's okay.
Absolutely. So we have processes that afford people due process and protections so that they're protected from these types of behaviors. The culture element is really important. In the aftermath of the shuttle Challenger and Columbia disasters, NASA stood up an organization led by a senior executive. He's currently a 4-time shuttle astronaut and a retired Marine colonel, heavily decorated. And the job of that office is for safety and mission assurance. And what it does is it actually promotes policies and processes, encouraging all employees to speak up on anything that could jeopardize safety and mission assurance. And they have the right to actually go directly to the administrator if there's a concern that may involve an accident to our programs.
Mr. Shi, you testified earlier that you typically are able to resolve beginning to end in 51 days, which is astonishing for the federal government and a pretty terrific record. Can you speak to how you're able to get to that resolution rate? And I know this is a process question, but what are your processes involved that lead to that culture?
Absolutely. Thank you. Thank you, Madam Chair. First of all, we have the luxury of not having a high complaint volume. Again, it's, I think, a credit to our preventative efforts. But then secondly, we have a separate program that's specifically aimed at addressing these issues. I coordinate that program. And it's not asset poor because it involves a collaboration of all of the organizations across the agency with equities and responsibilities to address this. And that includes Office of General Counsel, includes HR, includes senior leadership. And so this becomes a priority to us. Again, when we get a report, we basically feel that this is a good indication of something that might have been an unknown previously. We didn't know what we didn't know. So now somebody's actually stepping forward and giving us the gift of the information. We need to take it seriously. And so it's a priority for us to immediately contact the person and to be able to get the information from that person, particularly to assess whether there's a possibility of actual physical harm. So there's immediate intervention. And then with that information, then we gather additional facts and we prioritize, again, getting people to the table to be able to make a decision, including resolution. Our focus, though, isn't on legal compliance. Our focus in this process is really about what's in the best interest of the workforce, including our agency. And so we have to make the best decision. And even if there isn't a violation, even if it's an instance of bullying, that it's a very low level, we want to cut it off there before it gets worse.
Thank you. Commissioner Degling, Commissioner Gladney, I know you both have questions. In our remaining 10 minutes, I'm going to ask you to split the time. Commissioner Degling. Okay. We'll put your microphone on and go quickly.
Mr. Shi, I was wondering, when do you plan on finishing your online program, and also your training materials, the ones that are overarching and things like that? I was wondering if you could provide a copy of all that to the commission.
Yes, sir. Commissioner, thank you for your question. We're scheduled to, the training is actually completed. We're right now doing the Section 508 and the other technical components to ensure that it can be delivered across the learning management system across the entire country. I'd be happy to provide that and our current training to the commission and to anyone else that would like to benchmark with us.
Great. If you could, I guess, send it to us, OCRE, it'd be wonderful.
Thank you for that opportunity.
Thank you, Commissioner Gladney. My question builds on some of the discussion we've had today and picks up on the notion of culture. One way to ensure that we take these issues seriously in the context of culture is to make sure that they factor into promotion decisions, and that people who are found to be perpetrators of these types of bad acts on their employees and colleagues have consequences that impact their pathway to promotion, since it's inconsistent with our values and the law in many respects. So I want to understand from everybody's perspective whether or not there are mechanisms to adequately take account of this type of conduct and findings. How long do these things stay in the record? How are they taken account of when it comes, when the question is called about whether or not somebody should serve and have their sphere of influence expanded? The state and Nassau can take it in any order they want, and I welcome comments from all of the panelists.
So we do take that into account when individuals for Foreign Service, when they are under consideration for tenure to remain in the Foreign Service, for promotion, for appointment to senior level positions. Those names go through several offices throughout the agency to be vetted. Our office is one of those offices, and we flag, to the extent that that is someone that has come across our radar, we flag the name, pass it back to the Human Resource Office, because they are the program evaluation folks, or the office in Human Resources that is responsible for that. So we share those names that are flagged in our processes.
Let me be more specific. If somebody is found to have perpetrated a violation, a finding of sexual harassment, does that appear in their record?
I'd have to check then. I'm not familiar with the HR process. I'd have to check, and I'd be glad to check that and get back to you.
Because what you described as a flagging process to me seems a little idiosyncratic. I grant people their best intentions, but it seems to me that if there is an adjudicated finding of a bad act on the job, the typical way employers deal with that is to make sure it's recorded and known, such that it's traveling in a holistic way when that person is being considered for all manner of things. And a process that relies upon the institutional knowledge or memory of what the particular conduct of a particular individual was seems to me to be a recipe to let some people slip through who may not be in the best interest of the agency slipping through. So I think it's important, where there are findings of this type of conduct, that it be recorded, for some period of time, so that it's not a vanishing slap on the hand where the conduct is serious, and that factor be considered in the context of promotion. I'm wondering if, Ms. Ben-Yehuda.
If I could just respond to that to make a couple of points. One, sexual harassment and assault claims are not adjudicated as part of the background for Senate-confirmed positions at the Department of State, which is to say, if you go forward, you're being vetted to be a chief of mission or an ambassador. That is not a requirement on the Senate side. That's something that Congresswoman Spear is looking to change. Two, it is possible to receive a beneficial career transaction that is not a promotion. And in that case, information would not travel. For example, it could be very good for your career to receive the ability to move for a rotation to a different office, to take on additional responsibilities. That is considered really a gift in a really stretched workforce. That is often a key way that folks who are accused are pushed out and separated from people who have made the complaint. But it ends up benefiting the accused because they get an additional opportunity, whereas it's very difficult to come by otherwise. The same goes for additional training. Highly sought after trainings are often a great place to park people when they are a problem. I know we have limited time, but I do want to make sure we get to the backlog issue, which I do think is significant in the Department of State. Mr. Shi has pointed out to the 50-some days that it takes to adjudicate a complaint. I'd like to know what that current level is at Department of State. My understanding is that from 2017 to 2018, the number of cases reported doubled. I'd like to know if there was concomitant increases in staff to adjudicate that. And I do think for federal workforce wide, we need to look at caps on the number of cases a particular adjudicating officer, wherever he or she may be, can take on at a given time. Because to the commissioner's comment on corridor reputation. When a number of these cases are taking 18 months, 2 years to adjudicate, that silences people from coming forward, and it also can carry, the rumor mill for many years to come because it's not adjudicated in a timely fashion. Thank you.
Commissioner, could I answer your question? So at NASA, we have disciplined individuals for violations of our anti-harassment policy, but also in the course of doing a fact-finding for reported harassment, finding other violations of conduct that warranted discipline. That discipline goes in the individual's official personnel folder, so it stays with them. And it's considered both for suitability, clearance determinations, promotions, selections, and awards. And our efforts have been very effective. We haven't had a removal in my time there because we intervene and address these issues before they become a high-level issue. And I think our statistics bear that out. Last year, for an agency of about 17,500 civil servants and many, many more contractors, we only had 30 EEO complaints alleging harassment. And of those 30 EEO complaints, we had exactly 0 complaints alleging sexual harassment last year.
Time for one more. This is directed to Ms. Metcalf and Ms. Ben-Yehuda. So where folks are in fields with, well, let's take the field out of it. This happens in the context of employment very often, and people have to make difficult choices about the necessity of maintaining their employment and career possibilities and coming forward and exposing themselves to retaliation and other harmful carry-on effects of raising your hand. I'm wondering if each of you could speak to just how real those choices are for people and why having mechanisms and remedies in place to address in a meaningful way, not lip service, but in a meaningful way, this problem is necessary to make the nation's biggest employer, the federal government, be a model for all employees.
I'll say that those issues are very, very real. In my own research, there's hundreds of folks who have experienced these kinds of issues in their workplaces who have had to make really tough decisions. One case in particular, she was in a 3-year battle with her employer about a situation with a serial harasser in a tech department. And other women came forward too, and they ended up moving her departments, similar to my own situation in graduate school. They moved her and offered her a settlement, and she decided that the settlement wasn't worth it, that she wanted to fight it. And she actually went public in the media with this, but it ended up creating some backlash where she was getting hate mail at her home. She has 2 young children. People were coming by her home and she felt like her children were unsafe. She incurred tens of thousands of dollars in legal debt to pursue this case. And these are the kinds of things that people have to think about, as well as the emotional labor, concern about potentially losing her job and whether she should walk away from the employer, whether she should pursue with the EEOC. All of these things matter. And this is just one case among many where people are making these decisions. So I think this is one area where I think what you've described about NASA taking that cultural approach to making sure that it's not just about the legal process, but also about holistically addressing in the culture what's happening, so that this is something that everyone takes some responsibility for, really can make a big difference.
Thank you to this panel. We're at time. Mr. Smith, I hope that in addition to the HR information that you've already said that you would provide to us, that you also can collect and provide to us data responsive to Ms. Ben-Yehuda's question about what the backlog of cases is within your office and what the average time period is for resolution of cases and what the caseload is for investigators in your office. Is that something that you can provide to us? Thank you very much. I appreciate it very much.
Absolutely.
Thank you. Appreciate very much this vibrant panel and the work that you all are doing. Thank you. And with that, we will take our lunch break and reconvene at 1:10.